May I, Lordship? Lordship, I beg to mention item number 8.
Yes.
Yeah, item number 8, Lordship. Because senior counsel has came from Guwahati, but suddenly he got some fever, health issue, so he cannot appear today.
Item 9.
Item number 8.
8.
Item number 8, and there is another item also. Item number 14, 15, 16, 19, and 20.
One by one, madam. Item 8.
Item number 8.
What do you want?
Lordship, after vacation, matter may be list after vacation.
This is a transfer matter.
Transfer matter.
Who is for the state? Education department.
Yes, yes, we have already informed, Lordship. We have already informed them.
Affidavit has been filed.
Yes, Lordship.
Affidavit has been filed
Yes,
in item 8.
item number 8, yes.
We'll take it after 1 week.
After 1 week.
Item 8. Huh?
Lordship,
on the
Lordship,
ground of
Lordship, interim is there in
State,
item number 8.
AK request learn counsel for the petitioner has some health issues. MSD
Dear, you know.
Rilung.
Yes.
And counsel press for listing of the matter after waiting.
Lordship, interim is there.
Prayer is allowed. List after 1 week. Interim order passed earlier shall continue. After 1 week, we'll take it up. It's a transfer matter. Yes, then next.
And item number 14.
14.
14, yes.
14.
14.
14 for what? Orders,
Same.
we'll see. It's listed for orders.
Orders, yes.
We'll
it is
see.
in order. And
Item 14,
15,
15, 16,
16, 19, and 20.
19 and 20. We'll see. These order matters, we'll see. You be there.
May I, Lordship?
Yes.
Lordship, I have a mention for adjournment, Lordship.
Which one?
Item number 25, Lordship.
25.
Lordship. Lordship,
Why?
senior counsel is facing some personal problem.
2016 matter, no adjournment.
Last opportunity, Lordship.
Next week.
After vacation, Lordship.
What is the matter?
Passing for
Of what?
land allotment, Lordship.
After a week. On the prayer of Mr. Swen's learned counsel appearing on behalf of Mr. Arsa learned counsel for the petitioner. List this matter after a week. After a week.
Lordship.
Lordship, may I allow to withdraw item number 18? So
18.
this matter, the petitioner not want to pursue the matter.
Item
18. This matter, so petitioner not want to press the matter further.
okay. Mr.
Tabatokur, Titokur.
T. Topur, learned counsel for the petitioner, submits that he has an instruction not to press this writ petition accordingly. Writ petition stands dismissed as not pressed. Mr. So-and-so, Gitarak learned standing counsel RWD is present.
Obliged. Your Lordship, I beg to mention item number 9.
9.
Yes, Your Lordship. I've been instructed to withdraw the file, suit, Your Lordship. So I
Withdraw?
Yes, Your Lordship. The petitioner is no longer the petitioner is no longer interested in pursuing the matter.
Not interested. It's also already over. Permission is up to
Yeah, so it's
10/5, 2024.
It is fine.
Mr. Kate has a learned counsel for the petitioner. Submits that he has an instruction to withdraw this writ petition. Accordingly, writ petition stands dismissed as withdrawn.
Thank you, Your
As
Lordship.
withdrawn.
Your Lordship, I beg to mention item number 27. Maybe adjourn for today and listed after 1 week.
Item
27.
27. Yes.
Maybe listed after 1 week, Your Lordship.
What's there? This is what is the matter?
Your Lordship,
Item 27, you are not there.
Item 27, my lord, Margaret is appearing, my lord.
What is the matter?
land matter, Your Lordship,
Huh?
land matter, land dispute.
Right of where?
Yes, Lordship,
Hmm? You are for?
respondent, private respondent number 4, 5, and 6.
On the prayer of Mr.
M. Tasso, Your Lordship, Mindo Tasso.
Your name is not there.
Yes, Your Lordship, I have been assigned
On behalf of
Elbam.
Elbam, huh? Then on the prayer of Mr. Elbam, appearing on behalf of Mr. Elbam. Let's this matter after 2 weeks.
Obliged, Your Lordship.
Lordship, it's mentioned for item number 17, where means affidavit has been filed and even for dusty service report has been filed. So that may also listed for hearing for today only.
Huh?
That record may be called for today's.
You have
this-
filed an affidavit.
Yes, Lordship.
Not for hearing, we'll pass appropriate orders.
Yes, Lordship.
Also.
One, my lord, would like to challenge the subsequent developments, my lord.
Withdraw.
Yes.
Mr. Deepak, learned counsel for the petition submits that he may be allowed to withdraw this petition with a liberty to file a fresh list of Mr. So and so, learned counsel for the petition. Learned standing counsel RD is present. Next, accordingly, this petition stands closed as withdrawn with a liberty. With a liberty prayed for. Huh?
Okay.
Two also. Two also. Same order. This is Tiomo, huh? Same order. That's it.
May I please, my lord?
Hmm.
My lord, here the petitioner was appointed as the constituency peon in various in the same department. Some of them are serving more than 20 years. All the working under the same department in the post of constituency peon from the date of appointment, awaiting for the regulation of their service by promotion to DPC as per the recruitment process. My lord, may kindly paragraph 3 of my petition.
Who is department?
My lord,
Yes. They were appointed as contingency between various that in the same department. Some of them are serving more than 2 years. All the petitioners are working under the same department in the post position.
yeah, my lord, serial number 1 and 2 withdraw from the petitioner because their case has been already considered.
2 and 1 and
1 and 3.
1 and 3, they are no longer the petitioner.
Yes.
So,
Now remaining the 2, 4, 5, and 6.
yes,
Yes, ma'am. But kindly see page number 22, madam. Earlier,
yes,
married, madam.
yes.
Heart, sir, and sir, learned counsel on behalf of the petitioners also heard. Such as learned counsel and government affaring on behalf of all the respondent, having regard to the limited grievances expressed by the petitioner and other that is proposed to be passed, issuance of formal notice is considered not necessary and the case is
It's
taken up.
okay, it's okay, I've read it. Yes, they have rejected your case.
Yes, my lord.
Saying what?
My lord, is at page number 24, my lord.
24.
Yes, my lord.
Where is difference in so and so? Where would You're much junior.
Yes, my lord.
So
No, my lord, these private respondent are junior to me.
how? They are saying that there are so many seniors.
Yes, only the ground has.
The petitioner much junior and half of them, so many seniors is still awaited for observation regularly in the department.
Yes, my lord, but
Where is there any scheme for regularization?
No, Lord. There is
What is the rule?
no set rules regarding the contingent regularization.
Then why you are for private respondent?
I am for the department.
Okay, who is for
I'm
private?
a private respondent.
Why you have regularized their services? I mean,
On the basis of their.
why you have private respondent?
Lordship, what they have challenged is the officiating order. They have been,
Are you still officiating?
No, I have been regularized.
Regularized, then?
That order has been not challenged.
It's all right. Officiating itself is, if you admit that you are junior, how can you be regularized? What is the basis?
Lordship, there are many petitioner in present case. Only the one petitioner is senior to me, senior to us, and other, they are junior to me. They are claiming that they are senior to, only one petitioner.
Why only one petitioner? Even then, why? What is the mode of your regulation? How specialties do you have?
Lordship, on merits and. They have
What
been-
merit?
Lordship,
How the process work? I mean,
Lordship, the department on the basis that qualification on the merits and qualification they have been selected.
why they have not been considered? You could have considered all of them.
There is no Lordship as respondent number 4, 8, 9, and 10. They have been officiating on the officiating post and later on by means of DPC they have been regularized.
The basis you could have, they are contingency, or at least one of them is senior to the private respondent. Appears to be pick and choose. Which rule did you follow?
Lordship,
Is there any rule?
for regularization, there is no set of rules.
So there must be some
And-
policy,
And
and how is their general parameters?
for
If you don't have a recruitment rule or a particular policy.
appointment of group C and D, the head of the department is competent.
No, it's no longer there. You cannot. Even if it's for regular post, whether group D, group A, doesn't make a difference. There must be some set of rules. There's no rule.
Now it is in the year 2000, this is on 2017.
Huh?
2017. At that time, the department was following a notification. Lordship is aware, or the last occasion also there was a notification.
What notification?
Lordship, on the additional affidavit, we can come to page number 22.
Running page.
Additional affidavit.
Page 20, yes.
Yes, Lordship, this is the notification on which we were following, the department was following. And as per this notification, the appointment of group C and D, the competent authority is the head of the department. In this case, that would be the director of.
Empowered by the order to make such adaptation and modification of the law, whether they were appeal on. Yes, what you have done. This adaptation and modification of the law,
Yes,
by repeal of, what you have done in that case?
Lordship, by following this, the director is the competent authority to appoint group C and D.
Where it is? How do you know? How do we know?
Lordship, page number 29, starts from page number 29.
Yes.
And And page number 40 is the operating type copy. Last column.
Role group C, head of the department, office concern, not been. No, why not asking the authority? Or why not questioning the power of the authority? Issue is you have appointed on officiating basis, thereafter regularize some of the juniors of the petitioner. Why their cases are not been equally considered?
Lordship, not all of them were regularized, only respondent number 3.
Maybe with maybe one, maybe one. Maybe one.
Other than the respondent number 2, all are juniors. Lordship. Respondent number 2, petitioner number 2. I mean, the other than petitioner number 1, rest all the other petitioners are junior to the respondent. And
It's all right. Why is the criteria that juniors cannot be considered?
so their affair is only on the seniority. And
Then if you are this is your senior, then why you have not considered one of the senior, one of the petitioner who is senior to the respondents?
they are found to be more qualified as per their qualification.
No. You saw on the DPC that their name has also been considered.
DPC was only done on the year 2020.
Huh?
2020.
Still then,
And DPC is still pending for the rest. If there is post, and their name will be considered in near future if DPC is not available.
heard Mr.
Pomodi.
Modi, learn concept of the petitioner. Challenge made in this writ petition is to the speaking order dated 19/11/2016, passed by the Director of Horticulture, Government of Arunachal Pradesh, whereby the claim of the petitioner for regularization of their services, for absorption and regularization services as Group D post in pursuant to the order of this court dated 28/09/2016, passed in WPC 524 of 2016, has been rejected on the ground that the petitioners are much junior and above them, so many seniors are still awaited for absorption and regularization in the department. Mr. Next paragraph. The petitioners claims to be appointed on respective on various dates ranging from 2001 to 2010 as peon, contingency peon.
Yes.
Contingency peon.
Yes.
Not exactly peon. Order the appointment order doesn't say peon.
Where it is? Where is the appointment order?
Unskilled worker, affidavit page number, affidavit filed by the department.
Saying what?
Page number 8.
Contingency employees, will
Contingency
contingency employees in the Department of Horticulture. Please stop. It is contended that the petitioners, some of the petitioners have served more than 20 years. No, nobody is more than 20 years. Is serving in the contingency post. From for 6 years to 15 years. Mr. The petitioner, the respondent authorities have considered the case of the petition, the private respondents number 3 to
12.
12. Mr. Who, according to the petitioners, are junior to them. Mr. The petition, some of the petitioners, no, earlier you have approached this court,
Yes.
all the petitioners. We'll say some of the petitioners.
Yes, some of them.
You just confirm it, whether all the petitioners. Some of the petitioners approached this court by writ petition being WPC 524 AP of 2026. Listed. The writ petition was disposed of by the order dated 2809/2016. Directing the and has directed the Director of Horticulture, Government Arunachal Pradesh, to take on board the representation stated to have been filed by the petitioner on 15/7/2016 and passed a speaking order thereon in accordance with the law. Please stop. Next paragraph. The pursuant thereto, the Director of Horticulture, Government of Arunachal Pradesh, by impugned speaking order that is 19/11/2016, has rejected the petitioner, the claim of the petitioner, having been found that the petitioners are not eligible to be observed in their services on regular basis, since the petitioners are much junior and above them, so many seniors are still awaited for absorption and regulation in the department. Mr. Omodi, counsel for the petitioner, submits that some of the petitioners have been serving in the as contingency employee in the department for more than 20 years. List of the list of the petitioner, who is petitioner this thing, who is senior?
Well, here, petitioner one is
Now one, that is Yamin Thakur.
Yamin Tagru.
The petitioner number 1, who was appointed on 20/03/2001, is at least is senior to all the private respondents. Please stop. This Therefore, he submits that the authorities ought to have considered the case of the petitioners while taking up the matter for as the law requires that all the similarly situated persons are to be considered by following the same yardstick. And as such, he submits that the respondent authorities may be directed to consider the case of the petitioner for regularization as that of as has been done to the case of the private respondents. Next page. Mr. So and so, next page. Then counsel for the standing counsel, are you standing counsel? Horticultural Department. For respondent number 1 and 2, for horticultural department, representing the respondent 1 and 2, submits that. Except the petitioner number 1, the other petitioners are junior to the private respondents. Please stop. While drawing the attention of this court to the where is the page? Page 40.
Page 40.
This is what? This is what? This is what? A notification or what?
Notification.
Referring to the notification of the state, submits that drawing the attention of this court to the notification of the state of Arunachal Pradesh, whereby for appointment of all the Group C and Group D services and post, the head of the department is the appointing authority. Please stop. He submits that at the relevant point of time, there's no particular rule to regulate the appointment, observation, regulation of the contingency employed in the department. Please stop accordingly by following the general principle of appointment, regulation. The case of the petition, their private respondents were considered and having and on the basis of the merit and seniority as well as the qualifications, the case of the petitioners were considered and appointed initially on officiating basis, thereafter subsequently the service of the private respondents. Some of the services, some of the private respondents have been regularized. Please stop. He submits that the petitioners have not challenged the regulation order of the subsequent regulation order of some of the petitioner. Therefore, at this stage, therefore the writ petition would not be maintainable in view of the fact that the ground of challenge of the officiating regulation, the appointment of the private respondent is purely only on seniority, whereas except the petition number 1, the other petitioners are junior to the the petitioners, except the petition number 1, the petitioners are junior to the private respondents. He further submits that there are so many seniors whose cases are to be considered before considered for appointment of the regularization. Then the petitioner's hearing and the as and when the terms of the petitioners comes, their cases will be considered in accordance with the law. Next paragraph. Your submission, Mr. Executive,
I will
consider
rely
the
on the
private
listening
respondents while adopting the submissions made by the learning, endorsing the submission made by learning standing council for horticulture department submits that the accept the petitioners petition number 1. No, all the petitioners, but the petition number 1, comma, are juniors to the private respondents. This too. He also submits that since the regulation of some of the private respondent has been put to challenge, comma, the petition, no relief can be granted to the petition as the claim for the claim for objection of the regulations by the petitioners are only on the ground of seniority, which is not the correct position. Therefore, the petition is liable to be dismissed. Next page. Consider the submissions of learning council for the parties and also perish the materials placed on record. Next page. The petition, the respondents have failed to, respondent authorities have failed to place on record on what basis the cases of the petition, the private respondents were considered for appointment on officiating basis and subsequently regularized some of the private service of the private respondents. Except to say that the director of horticulture, being the appointing authority at the relevant point of time, has the power to officiate, appoint the private respondents. It is seen that while the cases of the private respondents were considered, no effort has been made to consider all other similarly situated persons, including the petitioner's hearing. If the state of the respondent is to be accepted, a respondent that the petitioners are much junior to the, the petitioners much junior, and there are so many seniors to be considered. Come on. The same has to be supported by the applicable, supported by the documents, as well as it has to be the appointments or consideration has to be, consideration or appointment has to be in accordance with the rules. It is noticed that it is noticed as admitted by the learned standing council that there is no specific rule to regulate the appointment of contingents contingent employees to the post of in the post of group D, which cannot be accepted in as much as once the post this sanction, there must be a rule or the guidelines or the general principle, and if not, a general principle of public employment, scheme of public employment has to be followed in any case. Mr. Are you still continuing?
Yes.
Admittedly, the petitioners, it is stated that the petitioners are still continuing as contingent staff, contingent employed in the Department of Horticulture. Mr. The law on regulation has been settled by the Honorable Supreme Court and clarified, settled by since clarified, but no, settled by the Honorable Supreme Court in the case of State of Karnataka versus Uma Devi within Petri, reported in 2006 for SEC, page 1. Huh? And same has been considered and clarified from time to time. List of at para 53 of the Uma Devi within bracket Supra, huh? Uma Devi 3 in bracket Supra. The Honorable Supreme Court has observed which is follows, which is reproduced here in below. Huh? Page 53, para 53. Next para. Recently, in the case of Jaggo versus Union of India, so and so, will give you 2005 so and so SEC online. Huh? I'll give that statistic. The Honorable Supreme Court has helped, which is reproduced here in under. Huh? Para 25, 26, 27, 28. Next para. Coming back to the reverting back to the present case, comma, and having considered as are still continuing as allowed to continue as a officiating employee in the Department of Horticulture, comma, it would be unfair if the authorities, the respondent authorities, in the name of appointing authority, to adopt the pick and choose policy to appoint their own choice of the employees, the contingency employees, which would not be permissible under the law. List. Thus, I'm of the considered view that the petitioners, and not only the petitioners, but all the similarly situated contingency employees of the department are entitled to be considered for regulation in accordance with the law. List of next paragraph. For the foregoing reasons, I'm of the considered view that the respondents are deserved to be directed to consider the case of the petitioner as well as other similarly situated persons, because contingency employees of the Department of Horticulture for regulation of their services. Accordingly, it is directed that the respondent authority shall consider the case of the petitioners along with other similarly situated persons for regulation of their services in accordance with the law. Before that, I'm of the for the following reasons. For the following reasons, and in the light of the law laid down within the Supreme Court, I'm of the considered view that the errors are deserved to be. Writ petition stands disposal in terms of.
May I plead, Your Lordship? Mala, in this matter, Mr. D. Das is appearing this matter. So, here requested that this matter may be listed up to vacation. And more about Your Lordship was also additional Advocate General when this matter was
I appeared.
pending.
I appeared.
I'm not sure, but then that time Your Lordship was additional.
So there would be so many cases when this court
Yes.
was additional.
Yes.
And there
So-
were so many cases when you were also appearing some other matter. So what does it mean? Unless I appeared in this matter,
Yes.
do I have any connection with this? You just tell us frankly. Nobody would like to.
So may I
If you have any reservation, obviously there's no hesitation. I'll request from the case, nothing.
No, I'm
I'm just asking. I still vaguely remember. That's why I was looking for it, whether I appeared
one of my client, he informed me that Your Lordship has appeared in this matter. That's what
in this matter. If
he.
that is the case, let us not list before this.
Yes.
Let us not make.
So date may be given.
This,
So, madam,
sir, if I cannot take up the matter, how do I give the list? Fix the matter.
madam, this can be listed after vacation.
Sir, if
First,
I
second.
cannot take up the matter, how do I fix the date? List this matter before before any other appropriate bench without me, huh?
I'm blessed.
What remains there? Might have completed by now.
My
Wise decision is to withdraw.
instructions from the client is that constructions have not taken place
So,
because though it is like 1 year now, but because of the conditions there and also the season,
how long it is?
Lordship,
What is the distance?
distance is around,
Village, what vibrant, what?
it's
program?
a green belt area.
Vibrant village program.
Vibrant.
Yes.
Private respondent will be able to say what is the total construction been done.
Obviously, you'll say that it has
No,
been
there has to be some report.
nearly completed.
Some status report will be there. That has been
Yes.
countersigned by the engineer.
What is the, period of completion?
Period of completion, 18 months, but
18 months of,
18 months.
18 months is, this is,
Last year, July, it was the letter of acceptance was given. But from the ground position, my client's instruction is that nothing has happened there till now. So if they can also give the status report.
it
So
cannot.
my basic case is that I was technically disqualified
Yes.
by citing a generic term
Hmm.
by saying that the equipments were not there. There are two particular clauses. One deals with the list of equipments, the other with the key personals.
Hmm.
Now, in the report, they have stated that I have not met with that particular clause.
Hmm.
I filed this writ petition before this honorable court stating, out of the 109 items, you should have specified
Hmm.
which particular item there is a shortcoming in the supply of documents.
Sir, yes.
Now, in their affidavit, they give two different clauses by saying that these were where I had faulted. Now, if your lordship will see the report in the writ petition and the averment in the affidavit, it does not tally. So therefore, my submission to your lordship is pleadings are otherwise completed. If the bid paper of the petitioner can be placed before the honorable court and can be looked at that particular point, I think it
So
will be clear.
the clauses they have referred
Yes.
while rejecting your technical bid
Yes.
is not the same as they're taking ground in the appeal.
Yeah.
Clauses are different.
Yes. So what has happened in the writ petition, I have annexed a report. They have submitted a report to me.
Yes.
In the report, they cite me two clauses.
Yes.
One clause deals with key equipments. 109 equipments are there.
Yes.
And the other clause, key personnels.
Huh.
But they do not
Key
tell me
equipment and key personnel.
key personnels.
Yes.
Now, in key equipments, there are 109 items. They say, I have not met with this clause.
Yes.
So I therefore asked them, out of these 109 items, which is the item that you say I have not submitted?
Hmm.
They don't point that to me.
Okay.
So I come before this honorable court.
Huh.
Therein they file an affidavit. Now in the affidavit in their averment, they refer to different aspects. They refer to me not submitting my work experience and some certificates I have submitted, but those certificates are not up to the mark.
Hmm.
So averment and the report does not tally.
Okay.
So therefore, if the records is brought, and from the record, everything will be clear. And then probably if it is not there, it is not there, then I cannot have a case.
Yes.
Sum and substance is that, Lordship.
Hmm.
So, आप record लेके आइए.
What is that, the report?
Yes, Lordship. That is at page 120.
Yes. Your
Yes, Lordship will come to page
Two.
121.
serial number 1.
Serial number 2, Lordship.
Serial number
HB
2, yes.
Enterprise.
As per the evaluation scrutiny, following clauses have been extracted. 4.3.
Yes. 4.2D and 4.4.
These are the only ground.
These are the only ground.
It's
Now, I can take your
about-
Lordship to this particular clause.
It is regarding key
Key
equipments
Equipments
and
and key personnels.
Ah.
Now, if your Lordship will see their affidavit,
Hmm.
therein at page 144. Lordship got it,
Who
144.
is respondent number 4?
This is the affidavit by the Secretary, Lordship. Secretary, Rural Works Department. Paragraph 1.
Page
Page 144. This is paragraph number 7, Lordship. Starts at page 143. In fact, page 143, last line, Lordship may see. Page 143. That the answering respondent states that the bid of the petitioner was rejected for failure to
page
meet the
144 or
143, Lordship. 143, last line.
para.
Para 7, Lordship.
Okay.
Last line, Lordship, has got that. Starts that the answering respondent.
Last line.
Para 7, last line, that the answering respondent state.
Hmm.
Yes.
Under clause 4.
Yes, Lordship got that.
Yes.
Now they refer to the first clause is okay, 4.2.d, and clause 4.4b, capital B, small b, 1. But if your Lordship will see at page 121, it is Roman 2. This might be a typographical error also. But then if your Lordship will read further, things becomes different. That
Details of the key equipment for road construction and field testing laboratory. However, due to failure in furnace, the required key equipment bid was rejected. Then
I'm just reading the paragraph, Lordship.
yes.
That the answering respondent state that under clause 4.2.d, paragraph 35 repetition, a bidder is required to provide qualification information. It is not true. I will just place, Lordship, 4.2.d. It is not qualification information. It is key equipments. Then they say, however, the petitioner furnished the details of monetary value of the civil works undertaken for only 2 years instead of 5 years. Further, as per clause 4.4 capital B small b Roman 1, a bidder is required to furnish the details of key equipments of the road works and field testing laboratory. However, due to failure of furnishing the key equipments, the bid was rejected. Now, in the report, they tell me my bid was rejected on key equipments and key personnels. In their averment, they have completely ignored the key personnel aspect. The key personnel is not there. And they refer to my qualification information, which is not in the report. They speak about monetary value of civil works. If your Lordship will see both the clauses, I can show both the clauses. They deal only with key equipments and key personnels and not my qualification and regarding Lordship monetary value of civil works undertaken. So it's not telling. The report and the averments are not telling. And this is by the secretary of the department. So therefore, everything will be clear if the records are there. Because my instruction in my reply also I have stated that I had submitted otherwise all the equipments. And my rates were also less.
Obviously, you will say so.
Yes.
Obviously, you will say so.
No, that is my case. That is why I am
Yes.
before your Lordships.
Is it correct?
This part I have to clarify.
So therefore,
Your affidavit, sir.
Yes, I am also confused like this.
If you are confused, you will allow the writ petition.
I think, my lord,
You cannot
There
file
is
an
some
affidavit
type-
like this.
But if you, my lord will see that section, this clause 4 itself, the entire clause is for the qualification of the bidder. If
No.
you also would come at page 35.
Of the affidavit. No,
Of the
read petition.
itself.
Read petition.
Read petition.
I'll place that clause then. I'll just place the clause.
Just wait, just wait.
Yes.
If learned standing counsel is confused, either of the two you clarify. Yes.
I'll place the clause.
No,
then.
I've understood. Let him try.
Clause
Yes.
4 is
Page,
my lord,
page
page 35.
35.
35. Okay. Yes.
4 itself, the heading itself is the qualification of the bidder, and under that, my lord, there are different sub clauses.
No, I will point therefore 4.2.d. What they are referring to is 4.2.d. Let me place 4.2.d then, Lordship.
My lord will see the
Now, Lord-
clause 4 itself is the qualification of the bidder.
I have been
And under
rejected.
that, my lord, what comes, my lord, that is under.
Yes, I have
There
been
are-
rejected.
Yes.
Sure.
So this qualification of bidders include any other, you meant to say that all the bidders, although
From what
specific, they have given the rejection to particular specific clauses,
4.2.d, Lordship.
sub clauses,
D is page
but then it
36.
will be, it's not only
From
this,
what I gather, it is also a qualification of the bidder itself.
including what? Including,
Uh,
apart from 4.2,
4.2D, including, because the clause 4 itself is for the qualification of bidder, and there are other sub clauses, then 4.1, 4.2.
so why they have not said the clause 4?
Lordship will see
For
4.2.d.
safer, they have given
D
the
is,
specific.
D is measure items of construction equipment.
Hmm.
Lordship will come to
But
this
fact
later.
remains that, forget accepting that, let us accept for a time being,
Yes, Lordship.
if they, even if they don't clarify the specific clauses with sub clauses, which they have
No,
mentioned.
they have clarified. in the report.
Other, they have,
Qualification of bidder mean.
other grounds can be a ground for.
Cannot be there because what has been communicated, they have to stick to that. Today, when I file a writ petition, they cannot better their case by bringing in new grounds of rejection. The rejection took place at that point of time. It has to be tested at that point of time itself, from that point of time itself. To substantiate their case, they cannot now bring in new grounds of not submitting monetary value of works.
Produce the record.
Otherwise, my lord, we are raising the issue of the maintainability itself.
Huh? Huh?
Maintainability itself. We are
No.
raising the issue of maintenance.
What is the image?
Because, my lord, this has been filed by, it's being represented by some person, my lord, who has not furnished anything to show that it is a attorney or authorized representative, nothing.
No, I have said that he is a duly represented
There is
by his
nothing on
authorized.
record.
I'll produce that. I'll produce that.
It
If
has to be,
they are
there
disputing
there
that
are-
today now at this stage, I'll
No.
produce that.
No, they have raised their maintainability on the issue. Have you filed your reply?
In their affidavit, have you brought that?
Because, my lord, there are decisions from our court
Affidavit we have.
saying that the proprietor has to be there.
Yes.
Proprietor cannot be substituted.
This
by
is
some
a
other
this is a
person.
partnership firm. I'll address that on the next occasion, Lordship, because this was
don't
now
think
been
this is
brought up for the
partnership
first time today.
No, you filed, you have.
Proprietorship firm.
Have you filed the affidavit?
This
I
is,
also filed.
You raised that issue.
Have you taken that ground?
Yeah.
Also raised that issue.
this is proprietorship.
I
firm,
haven't
not
filed a reply
partnership.
against the affidavit of the. Let me see. Private respondent.
Heard Mr. A.K. Sharma, learned counsel
A.
for.
Sharma.
Huh?
A. Sharma.
A.
K-
Sharma,
K is
learned counsel. No,
Proprietorship.
Kumar is, it's a universal.
I am not Kumar.
Huh?
I am only Anshuman Sharma.
We love to, there's an, one instance we come across. Non-tribals, they used to write.
Yes,
in the
they write.
text.
But from Assam, I think they don't use
Kumar
Kumar
and all
everywhere.
those things.
But
Yes.
UP side and all, Kumar is like very prominent.
So we come across some of the instances here in the state.
Yes, Lordship is correct.
By borrowing that, we have only title and the name.
Yes.
So we are also started using, some of them are using.
Oh, acha. Still, I'm not.
Say, for example, Duge Kumar Sokhi,
Oh,
Dike
acha.
Sokhi. Anyway, you produce the record.
Also, we fix it on some day along with the records. And also, I'll also answer on this aspect.
It's up to you, huh? We'll see. And you clear you make yourself clear.
His confusion should go.
Yes. You should clarify.
Both the
Mr.
matters are
A.K.
same. also.
Sharma. Affidavit in both the cases you have filed affidavit.
Yes,
You are appearing in both the cases.
Yes, in both the cases.
Okay.
And on same grounds, I have been rejected.
A.K. Sharma, learned counsel for the petitioners. It's going to be common order.
Yes,
Oh.
can be done. Only
We'll,
location is
we'll
different.
say pleadings are complete.
It is a complete.
Pleadings are complete. Next paragraph. Considering the clauses mentioned in the report of rejection of the petitioner's bid, technical bid, and the statement made by the respondent authorities, the stand taken by the respondent authorities in the affidavit. Come on. I deem it appropriate to peruse the record.
well, the report is called, let him, even the registration of farm is not annexed in the.
No,
Why are they so
keep
fighting on the method?
we'll
Cannot want to enter into the merits of it.
we'll keep it,
Yeah,
we'll,
yes,
we'll
yes.
keep it open.
It will be kept open, but then the records also be there.
That's why I asked
otherwise
you,
again another
asked
date
you
will
to clarify. Maintainability, in fact, these are all technicalities.
He must have a power of attorney. I'll find that out.
What I said? Peruse the record. Accordingly, the understanding counsel for the petition, the rural works department to produce the record on the next date. Since the since the respondents have seriously raised the maintainability of the petition, same shall be considered on the next date. As agreed to by learned counsel for the parties, list these matters after
Immediately after
3 weeks, 4
immediately
weeks,
after the reopening.
4 weeks, we'll just say 4 weeks.
Yes.
If a lawsuit will
By
give a
that time
date,
you complete it, and he may not like to submit. 4 weeks you complete it.
lawsuit will kindly give a date because as lawsuit was I'm outstation counsel, difficult.
Let us
sometimes to
be
give
very
that.
clear, unless there are very glaring
I
illegalities
understand.
or the
So I
bias
understand.
or
I'm just
all
doing
those
my
nepotism, favoritism, this court particularly would not to interfere with the matter.
I understand it, lawsuit, but
Because
I'm just doing my
it
duty.
hampers,
I'm just doing my duty for my
the, really, I mean,
Supreme Court has
impairs-
also clarified if
impairs
there are
the-
even if
the-
there are illegalities, construction works can go on and the
yes,
other side can
it's
go
very,
for
very
compensation.
difficult.
suit. I understand that lawsuit. The lawsuit will kindly give me a date. Otherwise,
After 4 weeks
otherwise it becomes very difficult to track lawsuits.
or
sometimes.
6 weeks, as you please.
4 weeks on a date lawsuit, particular date.
4 weeks, it's not me. 4 weeks.
After
will be-
after the
it will be
reopening-
vacation or
after the reopening lawsuit on
31st.
22nd of July,
any.
Tuesday. So 22nd of July.
Consider it is coming. Is from
Great
Guwahati.
decision.
Mr. Great Sharma is from Guwahati. So consider
That will be 24 more days.
24.
24th.
Huh.
Any date lawsuit, 24th applies.
Okay.
Applies to lawsuit.
Hmm.
May I lordship?
Yes.
Lordship, I'm appearing on behalf of it above.
Hmm.
Instructs me, we have some more given time for additional affidavit to
What?
file.
Time for
Additional affidavit.
what additional affidavit?
Just instructs me, take adjourn vote today.
What additional affidavit you want to file?
Senior was instruct me, arrest, adjourn, take adjourn for today and time for, filing additional affidavit.
How you can take for granted? Yes. Hmm. No pleadings are required.
Actually, the problem is 1 and 2 was repeated by the training council.
Huh?
1 and 2, it was repeated by the training
Yeah,
council.
sir, you are senior government advocate. What is the matter? Huh?
I was only for this, I cannot see.
Who is respondent number 3?
You see,
This is the one, he is all and all. He has issued a provisional land allotment and then it was cancelled on the ground that it will have it will disturb the landing ground. ALG.
now that is abandoned.
Now it has been abandoned. So you want to re-allot them. You want to re-allot them. We'll record your submission and we'll direct it.
I will take instruction.
Then it was filed when? Okay. 2025. Okay, recently.
Yes.
Heard Mr. So-and-so, learn counsel for the petition. Learn counsel, your name is there.
No,
Appearing on behalf of Mr. T.
T. Tapak.
Tapak, learn counsel for the petitioners. Mr. So-and-so, appearing on behalf of Mr. T. Tapak, learn counsel for the petition means that he would like to file, Mr. T. Tapak, no, petitioner would like to file an additional affidavit, therefore prays for listing of the matter after 6 weeks. 6 weeks. Mr. N. Long, learned senior government advocate, appearing on behalf of respondent, the deputy commissioner, also prays for.
All respondents.
You said you only for 3. Now you are saying.
Earlier I was for 3. Because
Then I'll ask.
1 and 2 had.
Then I'll request you to argue on behalf of respondent number 1.
No, 1 and 2, there was this thing, training council. So we didn't have any, record.
Learn senior government advocate. Appearing on behalf of the state, also prays for time to file, time to obtain instruction and file affidavit, considering the submissions of land consent for the parties. List the matter after 4 weeks. 4 weeks. Yes.
Last occasion, my lord, I was asked to bring written instruction, my lord. I had placed it on respondent.
Yes. You are arrested, you are a consumer.
My lord, in this
drug
case,
consumer. Huh?
I was wrongly
Drugs.
implicated in this case. So I'm facing trial in Session Court Pasigat.
Your casual contingency step. Why opportunity is required?
My lord,
It's a good ground. You become unproductive labor.
my lord, allegation in this criminal case is
Consumption.
not
You also consume. Or what?
my lord, possession and consumption of
Possessions and consumption.
consumption.
Then contingency step.
Yes.
How many years?
My lord, since 2007.
Where's the law that contingency step it involves or the principle of natural justice has to be adhered to?
Jasmine, my lord. My lord, paragraph 19, my lord. Relevant portion.
This is the appointment of registrar who has been appointed, selected and appointed for a 2 years provision, 1 year provision period. What is contingency?
My lord, here my challenge is that
What is the law requirement of department proceedings again the contingency stuff?
my lord, at least so cause notice. So, petitioner have to.
You bring on, you file an affidavit. Heard Mr. Omodi, then consult with the petitioner. Mr. On the prayer of Mr. Helper, learn consult with the learn standing to the power department. Who submits that he has received, he has obtained the instruction. No, only prayer, further, on the prayer, Mr. Helper Melan is in the standing council power department. A 2 weeks time is granted to file the, to bring on record the instruction as obtained by him by affidavit. List after 2 weeks.
Obviously.
What is this? ये क्या है? What is this?
Lordship,
What is this? Affidavit. Yes.
yes, Lordship, I'm for the petitioner, Lordship. Lordship, on last occasion, this honorable court has directed me to take justice service for respondent number 3, Lordship.
Okay.
And accordingly, Lordship, I had taken the service, Lordship, but the respondent number 3 has, Lordship, didn't accept the justice service, Lordship.
Refuse to accept.
Yes, Lordship.
Where it is? Where you made it?
Paragraph number 2, Lordship.
Who is respondent number 3?
Lordship, it's a private respondent, Lordship.
Okay.
Yes, Lordship.
Mr.
K. Mena, Lordship.
K. Mena, counsel for the petitioner has filed the affidavit regarding the proof of justice service upon respondent number 3. Next paragraph. It is submitted that the submitted as per the order of this court, that is 0805/2025. The petitioner has taken steps for service of notice upon respondent 3 by Dusty Moth. However, the respondent number 3 has refused to receive the notice listed. In view of the above, the service in respect of respondent number 3 is deemed to be served. What is the other affidavit? 2 copies. MSK have you filed the affidavit?
Yes.
Appears. The London Standing Council submits that she has already filed the affidavit on behalf of the state respondents. List the matter for admission hearing after 3 weeks.
Lordship. Obliged, Lordship.
May I apply? Yeah, bring your lordship. In this matter,
Award service report.
yes, respondent 1 to 4 and 9, they have not yet filed the counter affidavit.
In
Respondent is that,
respect of 9, there is the unserved notice has been received back.
okay, sir, your lordship.
Addressee moved.
Okay. Then, my lord,
You
we-
find out and.
then we may be allowed to do the justice service in this matter then. To respondent number 9.
Respondent number 8 awaited. You are 4,
Respondent number, they have already appeared.
1, 5, 1, 5 and 6.
Yes. We have already filed our affidavit.
Yes. State
8 we have filed.
8 they have filed, 7 and 8 they have filed.
service report in respect of respondent number 8 is still awaited. You are for 8.
Yes.
8 they have filed.
8 or 9.
But 1 to 4 also, I think they will appear for 1 to 4 by the state. 1 to 4.
4 1 I am appearing. Union of India.
Union of
One you are
India.
appearing.
1 5 and 6.
1, 5 and 6. Then state chief secretary
2, 3 and 4.
2, 3
And 4.
4.
Who is the chief secretary, your lordship?
Huh?
2 is the chief secretary. 7 and 8, your lordship, we have filed. That will cover your lordship.
7 and 8.
7 and
Why you are not
DC and
appearing,
SP.
why you are not appearing for Chief Secretary?
I'm
Home
appearing,
Commission.
Your Lordship. I'm appearing. I'm appearing for Chief Secretary.
Except 9, all are
Yes.
represented.
Yes, except 9.
Yes.
General Commander in Chief. Union also not only one. You are for 1.
1, 5 and 6.
Mr. Esmo, Learned Counsel for the petitioners.
Petition.
Petitioner.
Petitioner, yes.
Petitioner.
How many?
Only 1.
Petitioner. Mr. K. Lawyer, Learned Counsel appears for respondent number 1, 5, 6, 1, 5 and 6.
1, 5 and 6.
Who submitted that an affidavit in opposition has already been filed. And also MS G. Arbasar, London State Council appears for 2, 3, 4, 7 and 8.
Yes.
Yes.
Submits that she has also filed an affidavit on behalf of the state respondent. Next slide. Office note indicates that unserved notice in respect of respondent number 9 is received by Mr. is read for by Mr. Esmo, Learned Counsel petition.
You also may allow AD and Dusty Service both.
He's permitted to take process steps for service of notice upon respondent number 9.
Report.
Report.
About the high level standing committee.
Recommendings for upgradation of the post of radiography. You are radiographer.
Yes.
What is your post?
I am just a radiographer.
Recommends for upgradation of the post of radiographer under the Department of Health. So this is considered for upgradation.
Yes.
Yes. Do you have the copy?
Just I have received. Just received.
You go through it. We'll take it up day after tomorrow.
Yes.
If your grievance is what? For
Upgradation, madam.
upgrade is done.
Yeah.
Already recommended.
Yes.
It's clearly say because that process will take time.
Yeah.
So we'll close the method in view of this.
Yes.
All right.
Yes, ma'am.
Because you want that your post should be radiographer should be upgraded.
Yes.
So high level, what is called?
Screening committee.
Screening committee has already recommended action by health and family. This your department has to do, and it will take time.
Yes.
Procedure will take time. I mean, formalities. Or you may come back if it is rejected again.
Yeah. Then on that for tomorrow, as you suggested. Day after tomorrow.
Day after tomorrow.
Yeah.
It's of no use. We cannot say. Huh? You can dispose it off. We'll grant you if it is not done, you the liberty to come back,
Yes, yes.
approach this court. Really will grant you liberty. In view of this, we'll court this, right?
Yes.
And we'll close that. There's nothing to be adjudicated upon now.
So they have already accepted the
Ah.
the similar situated cases.
No, that's why it was placed before the high level committee and they have recommended for upgradation.
Yeah.
Clearly given in the last city. All right.
Yeah.
In the pay anomaly matter of radiographer. Heard Mr. Tis of London Council for the petitioners.
Petitioners.
Your radiographers
Radiographer.
under the health and
Health department. Health department.
Health and Family Welfare Department. And also had MS T. Wong London Council, London State Council, appearing for respondent number.
1, 5, 6, 7, 9, and 10.
Then and MS Mr. T. Tagum, London Standing Rules for Health and Family Welfare Department. Next para. By filing this writ petition, the who are working as radiographer.
Radiographer.
In the
Number
health-
47 altogether.
Yes.
47.
By filing this writ petition, the petitioners, 47 in numbers, working as radiographer in the Health and Family Welfare Department, Government of Arunachal Pradesh, have spread for a direction for revised scale of pay with pay as provided under fifth with similarly placed employees of the Department of Health and Family Welfare under the Government of Arunachal Pradesh. What there was a direction of the okay. The next grievance of the writ petitions was placed before the high level standing committee.
Screening one.
Screening or standing?
Screening.
In last order, this is mentioned. It should be standing. High level, this is recorded, last order. High level standing committee on pay anomaly. Accordingly, the today, no, not regular, please. Today, MS. Please look. On 11/03/2025, this court has directed the respondents to place the instruction accordingly. MS T. Wang Learned State Council as well as Mr. the TITAGUM, Land Standing Council for Health Department, Health and Family Welfare Department, by placing the communication dated 03, copy of the communication dated 03, 06, 2025, submits that the high-level standing committee has recommended for upgradation of the post of the radiographer the details which are reproduced here in below. Huh? This one. You just give this. Next paragraph. The learned on the perusal of the above communication. The perusal of the above communication clearly shows that the grievance of the petitioner appears to have been redressed by the Please. Next paragraph. The learned counsel for the parties have fairly, learned counsel for the petitioner has fairly, Mr. Tison, learned counsel for the petitioners has fairly submitted that the recommendation of the high-level standing committee for upgradation of the post of the petitioners has redressed the grievances, Mr. As agreed to by the learned counsel to the parties, and considering that the writ petition, the issue raised in writ petition, no live issue raised in this writ petition remains to be indicated, this writ petition stands closed. Needless to observe that the petitioner may, needless to observe that the petitioners are at liberty to approach this court in case the grievances as recommended by the high-level standing committee is not considered.
One thing that all the qualification also same that the class 12 science and staff nurse,
The
then your
Copy of the
EC technician.
communication that 30306 so and so is kept on record and marked as document X.
As per the latest 2016 15, the same I'm sorry,
Say
48.
In the, they are the party here. I
Yes,
mean
yes.
petitioners here.
Yes.
Say 48.
Within
Because since they have already recommended for upgradation, so it's no point to directing them to do it.
Yeah.
At best, we could have
Mal-
directed to consider.
some specific date maybe within a period.
No, we're closing it. Closing it.
Yeah.
Sir, you come back if it is not done.
No, some period maybe given it.
Period is very difficult. Because it's a technical problem. I mean, the formalities as to there are certain procedures.
Mobilize.
We'll talk with. Who is respondent number 4 here?
Private respondent.
This is, what is the case about?
This is, my lord, the in charge, my lord, the petitioner was earlier given in charge of midday meal scheme, my lord, and the directorate level. In the meantime, he has been transferred from directorate. Now, obviously, my lord, the midday meal scheme, no, it's not a sanctioned post, my lord. It's only engaged, my lord. Whosoever they are posted directorate, my lord, they are given charge to look after, my lord. That is the only. Now, when they have been posted, my lord, in the district, obviously have to, that in charge has to be given up. Saying that is the case, madam.
Okay. This court has rejected the interim prayer. Have you filed the affidavit?
Yes, I have filed. We have stated, my lord.
So what do you want? When do you want?
And then
You could
28th,
have disposed of the matter. There's no case. Tell your senior friend.
Lordship,
There's no case. After a week. Who
Lordship,
is appearing? Who is leading in this case?
A.K. Prakash.
Next week. Affidavit is completed. We'll be dismissing the writ petition. No need to of respondent. When do you want?
On 28th,
20.
28.
228.
Yes.
Okay. Although no, service report, service report in respect of respondent number 4. List of as spread by MS D. Rilung, Learned Counsel, appearing on behalf of Mr. D. Boje, A.K. Prakash, Learned Counsel for the petition. List this matter on 28 06 2025. This 28.
Yes. July
20th June.
20th of July.
He is asking
Okay.
20th.
What's
28 is certain. That's why I'm asking you.
He's
Is it
asking-
working there?
June or July?
July?
He's asking July, 20th July.
Lordship, 20th June is holiday, I think.
Before that,
27 or 25.
27 is
make it 27.
Yes, ma'am.
27. June, 27 June.
Declare.
These are all unnecessary litigations.
also for 15 and 16 is.
My lord,
This is also important.
IA is more what?
my lord, this case, my lord, become infractious, my lord. This
Yes.
is number 15, WPC 122, my lord. This was against the suspension of the petitioner. And IA, they filed saying that the mandatory period, my lord, 90 days has been expired. That has been done. In the meantime, my lord, what happened? That an entire proceeding, departmental proceeding that has been completed. my lord.
Concluded.
16 is challenged during the pendency of this item number 15. 16 was challenged, was filed challenging the memorandum of article charges framed against the petitioner, departmental proceeding. Now this entire thing, my lord, item number 15 suspension, 16 for department proceeding, this has been culminated into a logical conclusion, and he has been imposed a minor penalty of censure.
Then so that is under challenge.
Yes, madam. That is another challenge. This is under challenge in the writ petition, item number 8, madam. Now, in that view of the matter, madam, my respectful submit.
Transfer and the transfer is under challenge.
Yes,
Are
yes,
under
my lord. Only the item number 8 they have made challenge is, my lord, inadvertently, maybe because I have shot the instruction from the department. Instead of mentioning BEO, my lord, they have TGT, that could be a clerical and typographical mistake. They're saying that
without proceeding that they have been demoted. It may not be a case of demotion, my lord. So that is the only they've challenged the conclusion of the departmental proceeding at transfer at number 8. Now this 15 and 16 practically has become infractions because
Yes, suspension order.
yes, suspended has
It's
been
over.
and done.
Yes. And that is stay, IA 176 is stay of the suspension.
Yes, my lord. That is no requirement. This
In
all
122, they have challenged the suspension.
yes.
Yes. It's in process. Then
Now in that departmental proceeding,
and item 16,
at number 16, this is my lord, this is challenging the departmental proceeding. That is the article of charges issued to the petitioner, my lord. Now, basing on this departmental proceeding, finally departmental proceeding has concluded and imposed the minor penalty against the petitioner, imposing sanction. Now this also has become infractions, man. The outcome, whatever the decision has been taken, they have become that have made the challenge at number 8, the subject matter of challenge. Now these two writ petition become infractions.
yes. Madam,
Lordship, 15 and 16 is connected and item number 8 and 20 is connected here.
And
20.
that is together. 8 and 20. No, that is different. thing.
Ah,
15 and 16, that's it.
15 and 16.
why not on? Where on from
15
15,
and
16, 17?
No,
No.
my lord, only
15 and
15,
16,
yes.
yes.
This become infractions.
Do you agree?
No, Lordship,
Whether you agree or not, as per the records, you'll have to close it.
Lordship, let my senior to be appear.
So many suspension order to exonerate from the criminal case. How can we do that? Criminal charge and or to exonerate petitioner of the state criminal charge. How can we do that? Huh? Heard MS so and so learned counsel for the petitioner. A challenge made in this writ petition is to the suspension order dated 18/01/2024 issued by the who is the respondent number 2?
My lord, the respondent number
Where is the order?
at page 1, my lord, the commissioner, my lord, page 67, my lord, 167, my lord.
167 suspension order
167.
issued by the Commissioner of Education, Government of Arunachal Pradesh, Government of Arunachal Pradesh, issued by the petitioner. Was put to put under suspension. Stuff. The Mr. T. Tagum, London, Standing Counsel for Education Department, submits that in connection with the suspension, the departmental proceedings has also been concluded with the penalty of censure upon the respondent list of. In view of the above, the writ petition has become in process. Accordingly, writ petition stands closed as dismissed as in process. In view and then IA, in view of the order, disposal of the writ petition so and so. IA so and so stands disposal, huh? Then item 16, right?
Yes, ma'am.
What is this? Challenge, what is this?
Challenging the memorandum of article of charges.
Memorandum of the article charges issued by the, who has issued this?
My lord. $175. This commissioner, my lord, issued by
It's a challenge in
One
the challenge in the writ petition is to the departmental proceedings and the in terms of the memorandum of article of charges dated 10/05/2024 issued by the disciplinary authority, right?
yes, ma'am, disciplinary
Authority. Mr. Tagul friends, huh? The disciplinary procedure has already been concluded and the petition has been imposed with a penalty of censure. Therefore, matter has become in process accordingly. Writ petition instance dismissed and in process. Yes, close.
deeply applied.
Then you are mentioning we'll see. Yes. Yes, this is what?
Lordship, here means we file this additional affidavit, where means the project, land ability certificate and memorandum of understanding, those has been already cancelled now.
Hmm.
So almost it's in fractures. So meanwhile, but thing is that copy has been served to the Department Standing Council. So if they need required further instruction, they may take, but meanwhile, it may be stayed. Because
You said in process?
yes.
Which one is become in process? Writ petition.
No, not represent this. We prayed for the to sell the land ability certificate being issued by the additional deputy commissioner Chang Tajo. That has been cancelled by the concerned that officer only. And subsequent second prayer was that to cancel the MOU, memorandum of understanding, in between the department and the that one individual. That has also been cancelled.
So
Now we are into the e-procurement and IT being called by the department, this SE Rupa under this RWD. So in that regard, that may be stayed till if suppose they need instruction.
I don't understand.
My
I fail to understand. What is your grievance here?
My grievance is that as per the main writ petition, that my land has been illegally and means given NOC by one person that's 85-year-old who is actually very old person, and through him the additional deputy commissioner and DPIU executive engineer has entered one MOU, and based on that MOU, the department of this RWD, Rural Work Department.
You read your prayer first.
Okay.
Page 31.
Yes, Lordship. Yes. During the pendency, may I, Lordship, 31, page 31.
Just wait, sorry. Land availability certificate. This has been cancelled.
Yes, Lordship. We filed.
And the memorandum of understanding also cancelled.
Yes, Lordship.
Then
And now remaining is that this e-procurement.
procurement.
Yes, Lordship.
So what's wrong there? E-procurement press notice. What's wrong?
Because of this only subsequently that this e-procurement is the is arising out of the land ability certificate and MOU. So
Let us see, where is that? E-procurement notice. Where is the notice?
page 49.
49. Yes. Why you are saying that this is based on the land availability and the MOU? It doesn't indicate.
Lordship,
It's a
actually,
project under the, what is the vibrant village?
yes, Lordship. But
Huh?
yes, Lordship.
Vibrant village program.
Yes, Lordship.
So
Lordship, but
how you are agree?
agree in the sense, the 90% land belong to the villagers, and there are around 7 or 8%. One of that person who is very old from that family, he has been asked to sign MOU and issue land habilitation.
Cancel.
Yes. Now, I'm agree is that because it's a practice over here, Lordship, if suppose this e-procurement is not stayed or quiet, then what happen? They will forcefully bulldozer my
No,
area.
what's wrong in e-procurement? What is wrong with this NIT?
NIT has
Why
been,
you are challenging it?
reason is that based on this NIT only, they will start that project.
So let it be.
Lordship,
Why stay there?
without considering my land.
That's why I'm asking. You are challenging the NIT, right?
Yes, Lordship.
What's wrong with this?
Lordship, without conducting this, as per the PMGS road guideline 2019, without conducting transit walk, public hearing, they just.
Yes. What is your stand? You are the landowner. Your claims to be the landowner.
Yes, Lordship.
My lord, from the petition itself, entire act of the.
Is there any no man's land in the state where only the government project will be undertaken? You know,
This
this
is-
PMGS guideline doesn't provide you compensation.
Yes, Lordship.
My lord, this is all nothing but when tender is over, when the moment they don't get the tender, they started all these problems.
It's over. Tender is over.
Tender is open, but I have no instruction whether work is started or not. That I have no instruction. Now this gentleman.
See, PMGSY, this village, vibrant village program, there is no provision for compensation.
Yes, Lordship.
There may be certain guidelines which
Yes.
I think obviously they'll follow the guideline. I mean, these road, it's a road construction.
Yes,
Are you
Lordship.
not interested in the road?
I'm interested, but
Only you
Lordship,
have the helicopters. Helicopters requires the road also.
no, Lordship, if this type of
You
practice
just
is,
can fly with the chopper to directly to your house.
Now
It
they
cannot be permitted.
now they have cancelled the MOU land development. Then it's okay. We will cancel the road also.
What's wrong?
Hmm.
It's good for you.
I'm not against any project, but question is here is that
This NIT is for what? Is it for executive engineer or Mr. G. Tarakolni?
Lordship, the
Road
process,
is not for you.
yeah, that
If it is over your land. See, there are certain development scheme or the project where the compensation are being paid. At least where there is no compensation, spare them. It is for your development, for our development only. For common citizen. That's why I'm asking, is there any no man's land in Arunachal? Where the government projects will be undertaken and not someone's land, over someone's land. Sorry, sir. Should
Lordship,
not
but
allow all
this
these
this type of practice is continued, then
Huh? What
Everywhere.
type of practice?
Practice in the sense,
What type of issuance of a NIT?
yes, Lordship. Because
You are
NIT
against the issuance of NIT. You want
NI
that the work should be awarded on a pick and choose basis.
no, Lordship. We were, as per the record, as in petition also, I clearly stated that
Okay, what is your state
My lord,
to
they
file
come to page 59,
response?
59,
Yes,
59, page 59.
yes.
On the basis of the complaint lodged by the petitioners, the ADC has passed an order that there be a retransegua inspection. Then there is a report, page 59, where ADC himself is stating that matter has been settled. Then again,
61.
59.
page 59.
Yes.
That is also, this is top is 5th September 2024. Again, in the last dated change to the 24 August 23. Everything is
Yes,
What's
landowners have, they've agreed.
Lordship, subsequently, if you see,
Proper and due process of laws initiated to acquire it from the affected actual owners of the land. The affidavit was obtained by Sensor.
then next
A land,
62
no plot of land was found which is owned by the complainant. Huh? Disputed matter was resolved by by engineer Kacha Bang so and so, and so. Hence the matter is solved and is disposed of. Are you challenging this?
Lordship, yes. Subsequently, in page 60,
62.
62.
Then they say the same, on same indicate the same date. Here cancel without any citing any reason, unavoidable circumstances.
Same inspection
What
has
that
been
is-
cancelled.
Indicate a source. How these people are there intimidating the officers. This indicates source that.
Sir, advise your client.
Lord,
Not
Lord,
Mr. So and so, let me consent for the petitioner. Petitioners,
yes,
how
Lord.
many?
There are 4 petitioner representing 74 villagers.
For that 3 weeks time, 4 weeks time is granted to the state councils to file there. Standing council as well, the state council. You are for?
Okay, respondent number 6, private respondent, that person who has
4 weeks time granted, and Mr. So and so enters appearance, has submitted, he has instruction to appear on behalf of respondent number 6, for which he will be filing his power.
Yes.
List
Lo-
after 4 weeks.
Lordship, meanwhile, this may be stayed.
Meanwhile, Mr. T. Kipa, learned counsel for the petitioner is advised to, is directed to advise his client and to reflect on the issue as the issue pertains to construction of road for the public at large, which they were, wherein the petitioner themselves will be the availing the benefit.
Lordship,
I direct you to advise your client.
Lordship,
the
even
meantime.
affidavit, additional affidavit has filed that report has
Saying
been
what? Saying what?
saying that the landability and MOU has been cancelled. That record has been already filed before this Lordship.
We'll see.
Yes, Lordship.
In that case, I'm not there anymore.
Huh?
This was since.
No, we're not taking, we're not passing any order is additional affidavit. We'll see it. But seriously, I'm
Yes,
directing
yes,
you. This court is directing you.
Yes, Lordship. Highly honest.
Yes,
Lordship, here I'm for the respondent's lawsuit.
contempt.
We have already filed appeal lawsuit. This appeal number 16 of 25.
Huh?
Is it
Is there any stay?
and condonation has been lawsuit allowed, and then
Sir, you know, law is very clear.
they
Unless
just
there is an interim order, you'll have to
they went
comply.
lawsuit, that appeal was moved lawsuit. There
When
was
do
a
you want?
agreement from the senior friend also lawsuit. It may be taken up after lawsuit.
Lordship, after break.
No, it's a contempt matter. Your duty is to bring the notice of this court. Then your job is over.
Otherwise, may I pray lawsuit, can it be listed along with the writ appeal lawsuit?
Readable, no, that can,
After vacation lawsuit?
you have, no, after 2 weeks. What is the direction? What is the direction? What is the direction?
Lawsuit,
Ex gratia compensation.
lawsuit.
The petition, they said action has to be carried out within 1 month from the date of. Why not, nobody will stop from making a prayer, obtain an interim order.
Because on last week it came up lawsuit, but senior friend remained absent, so better for not pay.
No, it's a contempt proceedings.
No, not on contempt basis. So for appeal is concerned with some submitted lawsuit. Appeal was taken up last week lawsuit, but senior friend could respondent.
On the prayer of London Council, this MSD relo for the petitioner and Mr. Estaf in London Council for alleged contempt.
Lawsuit.
This matter after 2 weeks.
Up to.
Twenty also.
20 also. Yes.
After 3 weeks.
Your Honor, in this matter, I'm for the petitioner. I have received.
You are for 6.
No, Your Lordship, I'm for respondent number 7. I'm seeking.
It's not 1306/2025 indicates that, no, reflects that.
I have received affidavit on behalf of.
No report is in respect of respondent numbers is received back. For the list after 3 weeks.
Highly obvious.
Yes.
As on today, no
Answer
any response.
notice. Who is 2 and 3? Respondent number 2 and 3.
Private party.
They've refused.
Yes, we have sub.
Refused to accept. Respondent number 2 and 3.
Yes, sir.
Refused.
Refuse means we have sub copies.
Heard Mr. Tison learned counsel for the petitioner. Office note dated 13/06/25 indicates that the This indicates that answer notice in respect of respondent to entry. Notices, answer notices have been received back with a postal note refused RTS. In view of the above. Notice upon respondent to entry is deemed to have been served. Mr. Further, no, further. The award service report in respect of respondent number 4 for further 3 weeks. List after 3 weeks. MS so and so.
All right.
Have you filed affidavit? In the meantime, learn it.
They're challenging the
Council-
order of Gaubura, Your Lordship.
Hmm?
They're challenging the order of Gaubura. I'm for ADC, Your Lordship.
ADC.
Yes.
Anyway. In the meantime, state respondents, no, state council, Arbasa may file their affidavit. If required.
If required.
Yes.
But it is a tender matter, petitions are complete, can be taken up for disposal, I will not take much time.
Huh?
It will not take much time also. Petitions are complete, there is no interim order, so
So when do you want?
today, my lord, if you can.
Today is not possible. What about respondent? All are represented.
Yes, all are represented.
Well, formally listed for admission.
Admission. Tomorrow?
You have 4 respondents.
6.
Private respondent.
Yes,
How
ready.
many?
Everything is ready.
No. 7 is,
No, he is the beneficiary, 7 will obviously not.
okay. 7 is there.
Yes.
You are also appear.
6.
Okay.
6 is the beneficiary.
7 service completed.
Yes. That's the service.
And Mr. Deepak Lan, counsel for the petitioner. And Mr. G. Tarak, understanding counsel for respondent, and Mr. D. Picture for respond number 6. Non appears for the respond number 6, despite service of notice listed. It is submitted that the pleadings are complete. Mr. As I read to well and counsel for the parties, list this matter after a week for admission.
Within this week, my lord, there is no interim order, my lord.
Yes.
You said
They are ready, my lord.
ready
Wednesday.
Hmm.
Yeah.
and okay, admission.
18.
Day after tomorrow. Problem.
18th, make it 8. List on 18/6/060.
Problem.
17.
Yes, IA is for.
Yes, Lordship, for vacation and modification of infant order dated 29/4/25.
Yes. What's wrong there?
Lordship,
Why it should be modified?
Lordship, since the writ petitioner in the writ petition, he has already been completed the normal posting year, that is 2 years, and he has already completed 6 years, Lordship. The writ petitioner is already completed 6 years in the last posting place, that is at CHC Tooting, Lordship. And Lordship, applicant has already joined the release from the present posting place from on dated 17/3/25. And Lordship, the children of the instant applicant has already released from the previous posting place. That is from Mariam.
Yes,
Lordship, we have received I copy and this matter is represented by Senior Advocate M. Martin.
where is?
He instructs me take more time for filing rejoinder.
Next week. We'll dispose of them. Have you filed the affidavit?
Yes, madam. we have filed.
In the
Yes, madam. In the main.
main case? We're disposing, for disposal will next week. We'll just formally issue notice on this. Heard Mr. So-and-so, counsel for the petitioner, oblique, respond number 4.
Yes, Lordship.
Issue notice, just issue notice in IA, Mr. So-and-so, learned counsel, accept notice on behalf of the opposite party, oblique, writ petitioner, Next para. And sorry, so-and-so for respond number, the opposite party, oblique, respond number 1. Writ petitioner.
Writ petition, Lordship.
Opposite party number 1.
Yes, madam.
Yes.
And Mr. T. Tagum for respondent number 2, 3, 4. In IA is which the respondent opposite parties
2, 3, 4, madam.
2, 3, 4.
2, 3, 4.
One is writ petition.
In writ petition, heard so and so, learned counsel for the petition and Mr. T. Tagum for respondent number, learned standing counsel for
All. Health department.
Health Department and Mr. So and so for list for admission hearing on list for admission after a week.
Deeply obliged.
Thank you.
Yeah.
It's a dispute over the
Approach road losses.
I had
Come to page 37, madam. Impugn order. Page 37, madam. Straight away, madam. Impugn order.
yes.
Now, my lord, without any so-called notice, without following the procedure under section 4 of
Well,
the
it's a government land, you spare some more land, what's there? Where it is? Where is impugn order?
section 30, page 37, madam,
Of what?
of the writ petition.
37.
Yes, madam.
Okay.
Without any notice, madam, this impugn order was passed, madam. Eviction order was passed.
Eviction?
Yes, madam. By the estate officer.
4.5, your land has not been, it's a small area.
My lord, I have already given the person, the private respondent,
It's all right.
a right to land, right to approach to his land, my lord. And he has constructed 3-story building over the land. Now, what more he requires, my lord?
Where?
The private respondent, my lord. I have given him the road, my lord. There is a route. And he has over that, from that land, from that road, my lord, he has already constructed 3-story building, my lord. Now, what more is required, my lord?
How can there be a 3 stories building in a 3 meter?
They have constructed, my lord. It is not disputed by the, my lord, private respondent. There are, I have also personally seen the building, my lord. My lord, above that, my lord, I have already been given land allotment. During this process, my lord, my application was pending, my lord. Now, the subsequent development is that I have been given land allotment, my lord.
You have
So-
been given
Yes, my lord.
of how many total area?
Total area of
Minus this,
780, my lord.
minus this,
Minus
minus
this, my lord.
4.5. Minus 4.5.
I cannot say so, my lord, but
Then you have to be sure.
yes, my lord.
Otherwise, if this 4.5 falls under your allotted area,
My lord.
then only you may say. Even then, if it's a right of way, you have to give. You
But
have
there
to
has-
swear it's a government land.
Section 4 has
It's
to be
not your
complied.
ancestral property.
Yes,
That
ma'am. Section 4 has
Once
to
you
be
are
complied.
appointed, allotted, you cannot do this.
My lord, at least
See,
section,
right to way has to be respected and it should be.
if they have a, my lord, any issue,
We
my lord.
just have a narrow lane, it cannot be. Because there is reason,
My lord, they have constructed 3-story building, my lord.
we don't know.
My private respondent will admit, my lord.
Forget about it. Don't fight over this government land. You have to respect the public entry, road. You have to spare.
Let them issue notice, my lord, so that,
What notice?
my lord, para 21 of my writ petition, my lord. Page 19. May I read, my lord? That the petitioner begs to submit date. Page 19, my lord. May I, my
Para?
lord? Para 21.
Hmm.
That the petitioner begs to submit that estate officer has no authority to initiate proceeding against the petitioner for right of way of the private respondent under so and so. Having said that, it is to state that in order to be subject of above provision, precisely the person must be an unauthorized occupant of public premises. That being, in the first place, the petitioner is not an unauthorized occupant. Secondly, petitioner has not enclosed any public premises. Rather, it is the petitioner. Rather, it is the petitioner, it should be the private respondent who has, or rather, it is the petitioner who has said his applied land measuring so and so. So from 780, he has been given, my lord, a right to way, my lord, of 192.5 square meter, my lord. Rather, it is the petitioner who said his applied allotted land measuring 100 so and so square meter from 780 square meter with the private respondent. Thus, it is stated that the estate officer has no jurisdiction to try over the matter. So from my area of land, my lord, page 20.
Where's your allotment?
My allotment should be at my affidavit in reply, my lord. Probably. Affidavit on page, my lord, 13, my lord. My lord, I can also produce the hard copy, my lord. That is the allotment order. This is the order issued by the district administration, my lord.
Where is the reply? Yes.
So if they require, the administration requires to initiate proceeding, my lord, they has to comply with section 4, my lord.
Hmm?
Section 4 of unauthorized occupant, my lord. They have to serve me notice, my lord, so that I can respond, my lord.
Okay, earlier, who are you?
Darka Kamsi, my lord. He expired, my lord. Now I am the wife of Darka
Okay.
Kamsi.
In that case, I cannot take up. Please before any other improvements without me. The original petitioner was
Darka Kamsi.
late
He
Dr.
expired.
Kamsi. I cannot take it that's all. You could have pointed out earlier.
I thought
He has been substituted by whom?
by his wife. Now it is Moken Council is the wife.
First or second? First
First
or
first
second?
wife, first wife.
First wife.
Yes. I don't know the detail one.
You somewhere else,
Well,
some other appropriate beds.
okay, God bless.
Yes, what is
Yeah,
it?
Your Lordship. Lordship, item number 28, Your Lordship, 246, we have put to challenge the selection of the private respondent number 3, Your Lordship.
So it
And
has become in process.
Lordship,
It has become in process.
this has, because
Because
yes, yeah.
selection, they have decided to go for fresh selection.
Lordship,
Fresh selection.
yes, they have decided to,
Go for selection, fresh
yes.
selection.
yes, Your
To
Lordship.
which you have challenged item 29.
Yes, Your Lordship.
So once the selection of they have,
The selection which the authority was supposed to, they have selected in contravention of the NMC regulation, Your Lordship. There is a gazetted
they realize
notifications.
it's okay.
Yes, Your Lordship.
So they are not
So
appointing,
during the pendency of
they
this
have not
petition-
appointed the private respondent.
Yes, Your Lordship.
So it's become in process.
Yes, so during the pendency of this writ petition, they have, although there was a stay, Your Lordship, without leave of this court,
So
they
you,
have-
you want that they should be, the private respondent should be appointed.
to the extent of the first writ petition, my prayer was to,
Appoint you.
yes, Your Lordship, to set aside her appointment.
You're next in number.
Yes, I'm the only candidate in wait list, Your Lordship.
Wait list, what do you have? You have no right. If you are
That-
wrongly selected or appointed, then it has to go for fresh selection.
Your Lordship,
I
in
think
the,
privacy, the authority has taken a right decision.
no, Your Lordship,
You apply, you'll get it.
Your Lordship,
In the
in
fresh
that case,
selection.
I may be allowed to submit, Your Lordship. I would like to make submission.
This
Your-
28 were disposing.
In item number 28, in item number,
See,
yes, Your
now
Lordship.
wrongly or rightly, there's no question of appointment of the private respondent.
Yes, Your Lordship.
Now they have gone ahead. They want to go for fresh selection.
They have gone
That
ahead.
which you are
Yes, Your Lordship.
challenging.
But my prayer is to the extent my prayer was
Yes.
to,
We'll consider if they have the right to, whether you have a right to be appointed. Relying on, I mean, basing on the earlier selection. It is, I mean, deemed that they have done a wrong thing.
Lordship.
They've wrongly appointed, selected private respondents. So they want to go for fresh selection.
Your Lordship.
We'll determine in item 29, not
Yes, Your Lordship.
28.
Your
28 will, 28 will.
Yes, Your Lordship.
Closed.
Yes. So in item number 3,
And we'll consider, I will hear you on 29.
yes, Your Lordship.
All right. Item 28. In view of the order, which one? The decision to go for selection, huh? I heard MS and Anju. Learned counsel for the petitioner. And Mr. Tita learned counsel for the, learned standing counsel for health and family.
Yes, madam.
Welfare.
1 and 2, madam, representing. Respondent.
And
Respondent 3, private respondent 3.
1 and 2 is what? Trims.
No,
Prince,
Your
madam.
Trims and the state. Standing counsel for health and family welfare department.
Director Trims, Secretary Health and Family Welfare, and Director Trims, Your Lordship. Respondent number 1 and 2.
As well as respondent and representing, appearing for respondent number
1 and
2.
2, yes, madam.
And also Mr. B. Teacher, learned counsel for Private Respondent number 3.
Yes.
Were you appointed? Were you appointed?
Yes, I was appointed. Subsequently, after interim, that was suspended and finally cancelled, entire process.
Okay.
It was a common advertisement, Your Lordship.
Anyway, the challenge made in this petition was is to the selection result dated 20/06/2024. Selecting the private respondents, namely E. Shruti,
Lordship, is right.
to the post of assistant professor in biochemistry, and the consequent appointment of the said private respondent. Pursuant to the advertisement, where the advertisement?
15 March 2024.
Advertisement dated 15/03/2024
Lodge.
for filling up the post, various posts of what?
In various
Assistant
departments.
professor.
Yes, Your Lordship, assistant professor.
Interims. No, assistant professors in various departments. Various posts of assistant professors, including the assistant professor for assistant professor in biochemistry.
My lord, advertisement is 9 February 2022, my lord.
Okay.
No, Your Lordship.
9 February 03.
Page 29.
Page number 39, Your Lordship. Latest advertisement, which
Okay.
pursuant to this advertisement, selection was made.
Page 39.
Your Lord, yes.
Page 39
Yes, Your Lordship.
is the advertisement.
Is the advertisement, Your Lordship.
Pursuant to- Huh?
Latest advertisement, Your Lordship. Page number 39, annexure 8.
39.
Yes, Your Lordship.
15
Yes,
March.
yes, my lord, yes.
There is another advertisement.
15 March 2024.
It is submitted that during the pendency of the writ petition, the respondent authorities decided to fill up the said post of, where is the advertisement? Decision?
Decision, my lord.
27.
My lord, additional affidavit, my lord.
No, that has been challenged.
That has been challenged, Your Lordship.
In
In
the-
next writ petition, Your Lordship.
You tell me, which?
Page number 33 in next item number 29.
Yeah.
In our additional affidavit, my lord, page 199.
No, same order. This is a decision of the Commissioner Health.
Yes, my lord.
Huh?
Yes, my lord.
No, what I said? Assistant professor in biochemistry, the respondent authorities by the order dated 27/09/2024 issued by the Commissioner within Health and FW, bracket clause, Chairman Executive Committee, TRIMS, Government of Arunachal Pradesh. Has cancelled the appointment of, they said, E. Shruti as assistant professor biochemistry and directed to issue fresh advertisement for the same post. In view of the present writ petition has become in process. Accordingly, the writ petition stands closed at the instructions. Then 29 will hear.
Yes, Your Lordship. At
2 o'clock.
obliged.
Yes.
May I, Your Lordship?
Hmm.
Lordship, here is, in this writ petition, we have challenged the impugn order passed by the authority, that is annexure number,
Hmm.
that is at annexure number 5, Your Lordship, page number 33, Your Lordship. That this is the impugn order, Your Lordship, whereby the authority has issued an order for fresh direction was given to the authority to issue fresh advertisement, Your Lordship.
Hmm.
May I, Your Lordship?
Hmm.
The
Yes.
operative portion is para number 4, Your Lordship. Paragraph number 4, page number 33.
Hmm.
In view of the opposite backdrop of the present case, I have anxiously considered complaint dated 22/6/2024 lodged by Dr. Parida Jangju and also considered the clarification given by the Director Trims. Thus, having considered the entirety of the case, I am of the considered opinion that public notice dated 25/2/2022 issued by the National Medical Commission NMC stating that teacher eligibility qualification in medical institution regulation 2022 are applicable for starting postgraduate as well as super specialty course of medical institute lacks clarity, and as such, the same requires further written clarification from National Medical Commission in order to avoid ambiguity and legal complication in the future. The recruitment process, apart from the ambiguity of the public notice dated 25/2/2022 issued by NMC, it is seen that the scrutiny board for verification of the document of applicant was headed by Dr. S. Nageshwara Rao, head of the Department Biochemistry, TRIMS, who is admittedly the husband of Mrs. E. Shruti. Although, as clarified by the Director TRIMS, the scrutiny board may have no role in selecting the candidate on merit. However, very presence of Dr. S. Nageshwara Rao being the husband of Mrs. E. Shruti in the scrutiny board, the likelihood of personal bias cannot be ruled out, which casts doubt on the credibility of selection process of Mrs. E. Shruti as Assistant Professor Biochemistry. Thus, selection in respect of Assistant Professor Biochemistry is found to be vitiated, and as such, the same is accordingly declared null void. Consequently, the recommendation and appointment of Mrs. E. Shruti as Assistant Professor by order dated 26/24 stands cancelled with immediate effect. Upon cancellation of the aforesaid selection process, the Director TRIMS is directed to issue fresh advertisement for the post of Assistant Professor Biochemistry after obtaining written clarification from NMC, National Medical Commission in respect of public notice dated 25/2/2022 issued by NMC. So this is the impugn order wherein they have directed for issuing fresh advertisement, Your Lordship.
Yes.
This order has been put to challenge, Your Lordship.
Hmm.
Your Lordship, Your Lordship, according to the advertisement, Your Lordship, the rendered qualification, that is, I have annexed to 1, Your Lordship. Your Lordship may kindly turn to the advertisement, Your Lordship. Page number 18, Your Lordship. Page number 18. This is the advertisement, Your Lordship. Advertisement dated 15 March 2024.
Hmm.
Next
Yes.
page, Your Lordship. Terms and conditions, Your Lordship.
Hmm.
It has been clearly written. The rendered qualifications for the post of Assistant Professor is eligibility criteria as per NMC, Your Lordship.
Hmm.
So any recruitment for the post of Assistant Professor has to be done in accordance with the provision given in the statutory rules, Your Lordship. And next, Your Lordship, kindly turn to annexure 4, Your Lordship, page number.
Where is it as per MMC?
Next page, Your Lordship. Page number 19, Your Lordship. Terms and conditions, Your Lordship.
Hmm.
It has been specifically given, Your Lordship.
That is-
Eligibility criteria has to be as per NMC, Your Lordship. So I have annexed the National Medical Commission rules, Your Lordship. That is at annexure 4, page number 28. Page number 28, annexure 4, next page, Your Lordship. Page number 29, Your Lordship.
Hmm. Hmm.
Rule 3, this is teachers' eligibility qualifications in medical institution regulations 2022. So the recruitment has to be done in consonance with these regulations, Your Lordship. Your Lordship may see Rule 3, general norms for appointment of faculty in medical institutions. And Your Lordship may see 3.3, Rule 3.3, subclause Rule 3.3, Your Lordship. This is for non-medical. Respondent number 3 in the earlier petition was non-medical. She was from non-medical. I am medical, Your Lordship.
Huh?
She belongs from non-medical, Your Lordship. So as per in respect of non-medical, it's given, Your Lordship, in 3.3, Your Lordship. It says, in the Department of Anatomy, Physiology, and Biochemistry, non-medical graduates having MSc and PhD qualifications granted by recognized medical college institute as a regular on-campus course in the subject concerned can be appointed as assistant professor, Your Lordship. So this is my basic challenge, Your Lordship. She didn't possess any PhD degree, Your Lordship. Despite being ineligible,
You are qualified.
Your Lordship,
Are you qualified?
she was not qualified.
You are, what is your?
Yes, I am qualified.
What is your degree?
Your Lordship, table 1A, Your Lordship, page number 31. Table 1A, page number 31, Your Lordship, down below. This is the table 1A, norms for faculty appointment in promotions in broad specialties which are existence for more than 10 years. Next page, 32, page number 32, Your Lordship. Assistant professor, post assistant professor. I am MD, Your Lordship, medical. So my eligibility is assistant professor. Academic qualification is MD, MS, DNB in the concerned subject. Column number 3, teaching and research experience. 1 year as senior residence in the concerned subject in recognized permitted medical college after acquiring MD, MS degree. And table 1B, Your Lordship. 1B is for, again, non-medical, Your Lordship.
Non-medical.
Yes, Your Lordship.
You are medical.
Yes, I am medical, Your Lordship. Table 1B, index of broad specialties in which persons with non-medical qualifications may be appointed as faculty. Biochemistry, Your Lordship, may see serial number 2, biochemistry.
MSc medical.
MSc medical biochemistry with PhD, Your Lordship. With PhD in medical biochemistry. So the appointment, the selections and the appointment of each Shruti, respondent number 3 in the previous writ petition was done in contravention of these rules, Your Lordship. And that was put to challenge.
So she is not MSc medical biochemistry with PhD.
Yes, Your Lordship.
She is only,
she does not
only
have
MSc.
simply MSc, Your Lordship. She was pursuing PhD, but she has not obtained any degree as on date.
So whatever your.
I am eligible, Your Lordship.
You are MD.
Yes, Your Lordship. I'm medical, Your Lordship.
MD of what? Teaching and research experience you required. Assistant.
Yes, 1 year SR. That I have annexed in my previous petition, Your Lordship. That document was
Associate professor. Assistant professor.
Assistant professor, Your
MD, MDS, 1 year as senior resident.
as a senior residence, Your Lordship.
In a recognized permitted medical colleges.
Yes, Your Lordship.
After. So there is no dispute.
No, there's no dispute. That is why I have been kept in wait list 1, Your Lordship. So after the selection result was out, I came to know that because RTI was filed, Your Lordship. And as per the, that is in, that was annexed in the previous writ petitions. According to the RTI information, Your Lordship, she is serving not as a faculty in the TRIMS. She is simply serving as a tutor, and she does not have any PhD degree as on date, Your Lordship. And this advertisement is to be done as per the NMC, Your Lordship. So advertisement clearly it stipulates that NMC is the eligibility criteria as per NMC. That was not complied, Your Lordship.
Yes.
So that is why her selection was put to challenge. When the previous writ petition was filed, Your Lordship, petitioner was not aware of the appointment because regarding appointment, the petitioner was not aware. That is why, Your Lordship, the selection process was put to challenge. And now the authority, by issuing this impugn order, Your Lordship, I'm partially aggrieved, Your Lordship, to the extent of cancellation of the entire selection process and for the re-advertisement, Your Lordship. The impugn order is erroneous, Your Lordship. It's arbitrary. They are deliberately decided not to appoint me, Your Lordship, despite of being eligible. The post was advertised, post fallen vacant, and now there's no justifications why they cannot appoint me, Your Lordship. Being eligible, Your Lordship.
Where is your number in the select list?
Your Lordship may turn to Annexure 2, Your Lordship. Page number 20, Your Lordship. This is the selection result, Your Lordship. Serial number 3. Biochemistry, Assistant Professor, E. Shruti, and me, petitioner is at Dr. Pari Dajangju, waitlist 1.
Others, it has not been cancelled.
Others, they have not cancelled. Although this was the common selection process, they have only cancelled in respect of biochemistry, Your Lordship. Even the advertisement was a common advertisement, Your Lordship.
Say, for example, anatomy assistant professor, selected number 1, selected number 2. Oh, there are 2 posts.
Yes,
Some
in respect
posts
of
are
biochemistry, only 1 post was advertised, Your
That's
Lordship.
why I selected 1.
And waitlist 1, Your Lordship.
Waitlist 1.
Yes, Your Lordship. And in the previous petition, they have come up with an affidavit of opposition stating that the NMC regulation, the teacher eligibility qualification in medical institution 2022 is not applicable to her.
Why?
They are saying that as per because after coming into these regulations, Your Lordship, the previous rule has been superseded, Your Lordship. So now they have taken that stand, Your Lordship, saying that MSc qualification is MSc qualification is sufficient for appointment of assistant professor.
So what is the advertisement? This is advertisement of?
Advertisement, it clearly says as per NMC, Your Lordship.
Then 15 March 2024.
Yes, Your Lordship.
Then this notification is February 2022. There's any other subsequent notification?
No.
Qualification, eligibility qualification?
No. This is the existing required qualification regulations, Your Lordship. After coming into existence of these regulations, Your Lordship, any rules is redundant now, Your Lordship. Any recruitment has to be done in accordance with these regulations, Your Lordship.
The impugn order has been cancelled because the chairman.
Yes,
or
Your
what is
Lordship.
that?
No,
Committee.
scrutiny board, Your Lordship.
Scrutiny board was
Yes, Your
consist of the husband of
Yes,
the
E. Shruti, Your Lordship.
Shruti, and then there's no clarity in the medical council, this thing.
Your Lordship,
NMC regulation.
that is also, Your Lordship. Sometimes they are saying that NMC regulation is not for undergraduate, it's for postgraduate. That also in previous writ petition, they have sometimes they have stated that no, it's only for postgraduate. And again, they are
No, it's very clear. Clearly provides, the regulation clearly provides.
Yes, Your Lordship.
2022.
Yes, Your Lordship.
teachers eligibility for medical institution regulation 2020.
Petitioner has been denied, Your Lordship, arbitrarily denied. And has been kept in wait list, Your Lordship. So after putting into challenge of her selection process. Your Lordship.
This impugn order doesn't say that she is not eligible, right? Thus, having considered the entire, I move the consent of public notice decision issued by the National Medical Council.
My lord, whether who is
Teacher and medical engineer are applicable for starting procedure as well as super specialty pursued medical engineering. Lack
Then-
clarity and as such, same request further written clarification. Yes.
Then Your Lordship may say serial number 1 then, impugn order
Is
serial
there
number
any
1.
other notification regulating the eligibility
my
qualification?
lord, in their writ petition page 35, they mentioned, my lord.
Hmm.
It seems, my lord, there's it's only clarification with regard to regulation 2022, my lord.
In the previous petition, Your Lordship, I have annexed the entire,
In the writ petition page 35, my lord, this teacher eligibility qualification in medical institution.
NMC Act 2019 postgraduate medical policy.
There was this not public notification, there, these regulation 2020-22 applicable for starting postgraduate board as well as super special course from so and so. There was bit confusion, that's why that's clarified.
that has been
No,
clarified.
your notification regulation is 14 February 2022. It talks about 22 February. Page 35.
Yes, madam.
Followed in notification 2002-2022. Where is that notification?
Immediately thereafter, my lord, this it was notified on this MNC, the regulation notified on 14 February 2022. Now this page 35 is of 25 February 2022 after notification of regulation 2022.
No, you read this bold one. Recognition are advised to follow the notification of 2022-02-2020. Where is that notification?
My lord, that part.
Where is that notification? Your annexure, this page 27 is also not complete, I suppose.
Yes, madam.
Your Lordship, I have, and this annexure was annexed in previous writ petition also, Your Lordship. Because of the subsequent development, this writ petition was filed. So documents has been annexed in the previous writ petition, Your Lordship. If,
So is it the rules have been, complete rule has been annexed?
yes, Your Lordship.
Then why you have annexed the only a few pages?
Only the regulation 2022 I have annexed in the.
No,
previous-
it's not complete. It's up to page 32.
The relevant portion I have annexed, Your Lordship, regarding eligibility, Your Lordship.
This, madam.
This is the existing regulations, rules which, under which any recruitment has to be
Oh,
followed. Your
madam,
Lordship.
I'm asking why you have not annexed the complete rules. It's only consists of 4 pages. Maybe you say why you have just only the relevant.
My lord, just I have set up a spare copy of the entire regulation.
See, you tell us
Question.
public notice that it 22, what is this notification 2202-2022? Page 35. Advised to follow the notification of 22. Why you are annexing this? Page annexer 6, page 35. For what purpose?
Because in the impugn order, they have stated that after seeking clarifications of the regulations, it has been, Your Lordship,
My lord, my lord, excuse me, sir. My lord, this notification, although it is shown to be notified on 14 February, but it was published on 22 February. My lord. That is why this page 35, my lord, it's on 22/02/2022, my lord. This refers to the main notification at page.
It talks about this.
Yes, madam.
Yeah?
Regulation 2022. Although it is not dated 14 February, but it was gazette published on dated 22 February.
Where it is? Where do you-
My lord, in the first column in the, you will see the first front page.
page number 28. Your Lordship.
New Delhi.
14
Page
February.
28, my lord.
Ah,
Page 28, my lord. Under column, my lord, New Delhi, Tuesday, February 22. It's a gazette publication date, my lord.
page 28.
Yes, my lord. This amendment 2022, it was actually published on 22 February.
Okay. Date of publication has been used.
Yes.
So 35, why you are saying that? It's only for postgraduate,
My lord.
postgraduate.
35, my lord. That is why, my lord. In the 35, there's a public notice, my lord. 35. Notification dated, since the amendment regulation 2022, it was not notified by notification, ma'am. Dated 22 February 2020 in the Gazette, madam. It was published in the Gazette.
Notified, notification issued on 14 February.
Yes, 14
but
February,
Published in the
published-
official gazette in 22
Yes, madam.
February.
Yes, madam.
No, I'm asking why you are saying it's not applicable.
My lord, there's a, it appears to be, my lord, there's one thing, my lord. The first,
No, I think it appears to be a clarification that this notification teachers eligibility qualification will apply to the postgraduate as well broad as super specialty
Yeah.
courses from
Now,
the year
my lord, the
2022 to 23.
My lord, the
It's a
present-
clarification only. It
Yes.
doesn't say that you cannot say that it doesn't apply to the
my lord, this is not a case.
assistant professor.
My lord, only in this.
And your advertisement clearly said it should be as per the NMC's norm.
My lord.
So
My lord,
it appears to me this public notice is a way of clarification that for the postgraduate and the super specialty
yes,
courses,
my lord. Yes, my lord.
that will
But in
apply.
the present case is undergraduate, my lord.
Therefore, this is a clarification. It
Yes,
doesn't
yes,
say
ma'am.
that that
Yes.
will not apply.
Yes, yes.
Then why you are saying that this will not apply?
My lord, that's why this only applicable to postgraduate, super specialist.
It doesn't say so.
My lord, that is right, but they have
These regulations are applicable for starting postgraduate. That's what I'm saying.
they have understood in that way, my lord.
No.
And moreover, my lord, they
Then
are,
which regulation applies?
my lord, in this case, my lord, there is a,
You said as per the advertisement, you said as per the NMC.
my lord, in NMC, my lord, 2022 regulation, there's a saving clause 14, my lord. There's a saying that in the saving clause, my lord, I have given, my lord, that any appointment made, my lord, under the minimum qualification for a teacher in medical institution regulation 1998, my lord, that will be protected, my lord. Now, our submission is, my lord, why this Setu was considered, because he was already serving as a assistant professor in somewhere other, the College of the Medical Institute of the India, my lord, prior to the 2022 regulation come into force, my lord, in various institutes, my lord. That's why, my lord, since he had already acquired
This comes since when it is come into effect?
from date of publication on 22 February.
22. Where is your advertisement? 15 March.
My lord, that part, my lord.
And why do you have to do this? Why you clearly mentioned for assistant professor, MD, so and so, 1 year senior resident in all this thing. Why you have to mention it if it's only for the postgraduate?
No.
This public notice is, I think, tries to convey that it also apply to the postgraduate.
My lord, another
and
thing.
super specialty.
Yeah, it also applies to it. But in the clarification, my lord, in the impute order, my lord, there is a direction from the commissioner to get a clarification from the MNC, my lord, in this regard. So in regard to
Suppose
this,
if it doesn't apply,
my lord,
what is the eligibility criteria?
my lord, this is
Qualification, eligibility, teachers eligibility qualification.
as per MNC clarification, my lord, dated they've 16 February 2024, they say that MSc is MSc, MSc is sufficient, madam.
16 February.
Yes, madam. In our affidavit, we have sought a clarification from the MNC, and MNC in our reply to our request, they have furnished this written clarification at page 54 of our affidavit, madam.
Where it is?
India affidavit, Your Lordship.
Where is the affidavit? Affidavit in this. You have not filed affidavit here.
Well, I filed the affidavit, ma'am. Filed on 7th May 2000.
Yes. Page 54.
Page 54, ma'am. Perat in this case. My lord, earlier it was lecturer, now it become assistant professor, my lord. As per 1998.
He said it may be
MS
noted prior to 1990, MSc qualified person could be appointed assistant professor. Huh?
my lord.
However, in terms of the minimum so and so teacher, it is rated in the Department of Anatomy, Physiology, Biochemistry, Pharmacologist, and Microbiology, non-medical may be appointed to a extent of 30% of total number of posts in department.
Non-medical
A non-medical approval medical
MSc
MSc shall be a
sufficient
sufficient appointment
as a lecturer.
to promotion to. This was under the 1998.
My lord.
Huh?
My lord, my submission, my lord. Since Shruti was already serving and was already appointed, and her qualification as a assistant professor was already recognized by MNC prior to the coming of regulation 2022. Man.
It's not a
So
question of regulation. They when you are recruiting, selection process is undertaken. That is the last day of this thing. The regulation in vogue will be applied.
Malo, that is the stand of the department that I'm making.
See, it's like you have the recruitment in 2000.
Malo.
The earlier qualification request was a class 10.
Malo.
Now you are recruiting in 2022, which provides the recruitment rule provides class 12. So since they were having a class 10, before the recruitment rule, at the time of recruitment also you are making them eligible. It cannot be. And this, what clarification this is also?
Malo, that's.
How can he say that he has clearly mentioned here, para 2.
Yes.
Para 3 is trying to confuse.
That is why, because of the department.
This cannot be accepted. He
Now-
is rather confused.
Malo, only our department.
That's why you have appointed her.
Yes, Malo, department stand is Malo. That's why, Malo.
Now, how can you, do you read it? However, in terms of the minimum qualification, why you are seeking a clarification after the coming into force of 2022, right?
Malo, yes. Malo,
Then
page-
he's referring to the 1998 rule. Which rule is it? It's applicable.
Malo, prior to notify that 22 February 2000, it was notified new rules. And prior to that, Malo, the 1998 was enforced.
It's all right. When did you issue your advertisement?
Malo, that is right. Before, after enforcement of new rule. That is, Malo, that is what the state of the department, Malo, that on these circumstances, Malo, he was allowed to participate. And in the.
There's no other rules.
Malo, there's no other rules. 1998, only our the state we.
When was the selection process? When the select list was published?
Select list was published on
June.
Yes, ma'am.
You have sought the clearance 16.
June 2024, 20 June.
September you have sought. You have sought the clearance 30th September 2024.
Yes.
It may be noted that prior to 1998, MSc qualified person could be appointed. Who is disputing that? It is reiterated that in the department, so and so may be appointed to the extent of 30% total number of gross in the department. A non-medical it shall be sufficient qualified for appointment as lecturer in the subject concern, but for promotion to have teaching. He's talking about the requirement of 1998.
My lord.
Which is no longer there.
No longer there. Only, my lord, this is the department state, my lord, although it may not be acceptable.
It's not acceptable.
My lord,
clearly it's not acceptable. But are you still following this rule 98 or 2?
No, my lord. Now new rules come into play. Only their confusion was that matter, since he was already serving as a assistant professor during the enforcement of
Problem is,
1990.
sir, if the appointing authority or the state is confused of the rules and then making an appointment, there will be chaos.
Matter that part's there.
Therefore, you are there.
That is
You will have
why
to tell them. There's no confusion.
that is why, madam.
See,
From
you
my
may,
side-
if you have initiated the selection process before coming into force,
Madam.
there may be it is debatable. The notification, the regulations came into force
Madam.
22. Thereafter, only you issued the advertisement in much later in 2024, where you have clearly said it should be as per as. I'm still asking which rule will
But obviously,
govern.
2022. My respect rules. It is my understanding and it's my submission. But so far, that's why, my lord.
This clarification, this person who has given the clarification is also something, I don't know. Who is
Because of this only, my lord, the confusion arose, my lord. That is.
This is who? Who is this? Director.
That is their understanding, my lord.
This is by the clarification postgraduate medical education board. What is postgraduate medical? Are we concerned?
My lord, here we are not
This is
concerned.
undergraduate.
My lord, this is undergraduate, my lord. We
Then
are present case, my
why
lord.
this
Now,
director of the postgraduate medical board has to clarify?
it says that this rule 2019, my lord, which notified on 2022, my lord.
See, your page, annexure, page 54. This is medical NMC, right?
My lord.
Postgraduate Medical Education Board. Is this board looks after this commission looks after the undergraduate also? Cancellation is also not on the ground of all this eligibility.
My lord, the
Cancellation is
consideration,
number one is there is a likelihood
Yes.
of bias because the husband was the
yes.
chairman or scrutiny committee,
Yeah.
member of the scrutiny
Yes.
committee.
My lord, this.
Number two, there is no clarity
Yes, madam. Only that part, madam.
on
The eligibility part that has not been considered, looked into by the authority, madam. Only since
In
there's
fact, that should have been a consideration
my lord.
whether these eligible or on the basis of the regulation.
There
My
was no
lord,
input.
since it was the order was passed, my lord, on the basis of representation made by the petitioner, saying that there's an element of biasness, and in order to maintain the reputation of the institute, my lord, this has to be rectified and looked into.
Why you
Accordingly-
cannot appoint he or she?
Your lordship.
Why you cannot appoint him?
My lord,
He was what list?
my lord, he's in wait list, my lord, since already for
There
all.
is a stay also.
Yes, your lordship.
What is the stay? What is the order of this stay is what? Shall not appoint any such can include as assistant professor by Community Institute pursuant to the advertisement and the in violation of the requirements as has been prescribed by the National Postgraduate Medical Board. As has been prescribed. What is this addendum? Addendum is what? Addendum
Your lordship.
2204-2024. What is this addendum? Addendum after the this thing, advertisement. Is there any addendum?
No, your lordship.
Is this mentioned this? What has mentioned addendum dated 22/4/2024?
After filing of the previous writ petition, your lordship.
No. You come to page 26. Advertised numbers in the para 14. Interim order. put one AC of the one AC.
In the interim, it is made clear that the respondent number 1 and 2 and any authority concerned shall not appoint any such candidate. Addendum, the public notice which they have annexed in their affidavit in opposition, Your Lordship.
There's addendum. Hmm?
Yes, they have stated that the regulation is not for undergraduate, it is for postgraduate. Therefore, that public notice was annexed in the affidavit in opposition, Your Lordship.
Okay, this rule is, regulation is by the Postgraduate Medical Education Board. Okay. So,
My lord, only in all fairness, in order to maintain all fairness, my lord, this the way directed, we have decided for re-advertisement. He can also participate any more because there was an allegation. That's why only to clarify that to maintain sanctity, to maintain all fairness, the authority has taken.
if she had not been appointed,
My lord.
selected, who would have been?
My lord, that is there.
You
That-
keep him, you have yourself as put him, keep him as at least one.
My lord. I'll leave up to the my lord.
This will save your thing also.
My lord, I'll leave up to the my lord.
Heard. তুমি পারবে না পারবো send Victoria. Can you do it? Heard Mr. MS and Anju, learned counsel for the petitioner, and also heard Mr. Tita, learned counsel for the learned standing counsel for Health and Family Welfare Department. For respondent number 1 and 2,
Yes, ma'am.
right? By instituting this writ petition, the petitioner has put to challenge the order dated 27 and put to challenge the part of the order number trim so and so, page 33. You read dated 27, part of the order, huh? That, number being numbered trim so and so, page 30, right side, left hand side, dated 27/09/2024. Passed by the Commissioner within bracket Health and Family Welfare, bracket close, come Chairman, Executive Committee, TRIMS, Government of Arunachal Pradesh, whoever. Comma, by cancelling the selection process in respect of cancelling the selection of one Mrs. E. Suti, selection and appointment of Mrs. E. Suti as Assistant Professor Biochemistry pursuant to the advertisement dated 15/03/2024, has directed to issue fresh advertisement for the said post of Assistant Professor Biochemistry after obtaining written clarification from the National Medical Commission within bracket, in short, NMC. Please stop. Briefly put, comma, the petitioner is what your MD,
Medical, Your Lordship. Yes,
Huh?
MD, medical.
medical what?
It's simply medical, Your Lordship. She's from non-medical, I'm from medical.
No,
And-
no, what is MD?
Medical, Your Lordship. Medical, non-medical. MD stands for medical, Your Lordship.
No, forget about it. Is working as junior specialist. Is still your junior specialist?
Yes, yes, Your Lordship.
In the Bomdila, in the General Hospital, Bomdila, West Kameng District, under the Health and Family Welfare Department, Government of Arunachal Pradesh. She has been prior to her joining as the junior specialist under the health department in the state of Arunachal Pradesh. She had,
He, Your Lordship.
he had worked as senior resident at AIMS Devgar, AIMS Devgar. AIMS Devgar,
Yes,
Deogar,
Deogar.
Deogar. Which state? For more than a year. Next para. And advertisement. The respondent authorities. No. The director of within bracket trims bracket clause by an advertisement dated 15/03/2024. They said the director trims issued an advertisement dated 15/03/2024 calling for interview for filling up of various posts of professor, assistant professor and assistant professor in different departments. List of the petitioner having the eligible having the eligible and requisite qualifications as per the NMC regulation 2022 regulations, 2022 has applied for the post of assistant professor in biochemistry. List of after the interview, only it was an interview.
Yes, sir.
After the interview, no, Mr. On completion of the interview, a select list was published by order dated 20/06/2024. For the post of professor, assistant professor, and assistant professor of TRIMS faculty. On the basis of the recommendation of the selection committee, including the assistant professor biochemistry, including the post of assistant professor biochemistry, Mr. In the said result notification and a selection result, sorry, in the said selection result, one e-Shruti was selected, whereas the petitioner's name appears as waiting list number 1. List of next paragraph. Having found that the respondent authorities have selected one e-Shruti who is not eligible to be appointed as per the NMC regulations 2022. The writ petition, the petitioner has filed approached this court by filing the by way of writ petition being WPC 246 of 2024. This court by order dated 25/06/2024 has directed the respondent number 1 and 2 not to appoint any such candidate, including the respondent number 3, within bracket, once the e-Shruti, Mrs. e-Shruti, bracket close, as assistant professor of the biochemistry in the TRIMS pursuant to the advertisement dated 15/06/2024. Mr. During the pendency of the said writ petition, above writ petition, the commissioner, by impugn order dated 27/09/2024, the commissioner within bracket health and family welfare chairman executive committee, TRIMS, Government of Arunachal Pradesh, has cancelled the selection process, selection and appointment of Mrs. e-Shruti on the on having found that the husband of the Mrs. e-Shruti, head of the department, of biochemistry trims. Was the was the what is it? Head of the department headed the scrutiny board for verification of document of the message e-shruti and the and on likelihood of personal bias and the as well as to avoid the ambiguity and legal complication in future regarding the NMC regulation with regard to applicability and eligibility education education qualification has cancelled the no we have said cancel and thereby directed to issue fresh advertisement for the post of assistant professor biochemistry after obtaining the written clarification from the NMC. Mr. Being agreed of the part of the order, particularly for issuance of a fresh advertisement for the post of assistant professor biochemistry, this present writ petition has been instituted. Mr. MS N. Anju, Land Counsel for the petitioner, submits that as per the teachers' eligibility qualifications in medical institutions regulation, 2022, issued by notification dated 14/02/2022 by the NMC clearly provides the eligibility qualification in the medical institution, as per the said rules for the post of assistant professor for medical what? Medical,
Non-medical.
for medical, one must have the education, academic qualification of MD, MS, DNB in concerned subject with teaching and research institute experience of 1 year as a senior resident in a concerned subject in a recognized public permitted medical college after acquiring MD, MS degree. He submits that the petitioner, having been undergone and worked as a senior resident in a renowned AIMS Deoghar, in the state of Uttar Pradesh. Deoghar is where?
Your Lordship, that
AIMS Deoghar, you find out the state. Jharkhand.
Yes.
Jharkhand, in the state of Jharkhand. With MD. And being a medical, what do you call it? Medical? No, I'm not sure. It is what it is 3.3 what says in department and general norms for employment of faculty in medical science.
Medical postgraduate.
Then where is this non-medical?
Non-medical is table 1B, down below your lordship.
Page that will same, my lord.
Table 1.
Non-medical qualification, medical qualification MD, huh? There is no dispute to the eligibility of the education qualification of the and the other eligibility of the petitioner. And he having been selected as voting list number 1. List of. It is also she submits that since one MS Shruti, whose appointment selection and appointment has been put to challenge by the petitioner within bracket. Now the selection and appointment of the set of the Mrs. Shruti has been declared null and void and cancelled, comma, who has only degree of, who has only education qualification, MSc.
MSc.
MSc without PhD in medical anatomy. No, with the BSc, MSc within bracket medical biochemistry without PhD in medical biochemistry is not at all eligible. In as much as the education qualification for non-medical qualification for the post of assistant professor in biochemistry requires a candidate must have the education qualification of MSc within bracket medical biochemistry bracket close with PhD in medical biochemistry. Please stop. Therefore, no, please stop. She further submits that as per the advertisement dated 15/03/2024, the terms and condition has been clearly provided inter alia that the eligibility criteria shall be as per the NMC. Please stop. Next one, Mr. MS N. Council further submits that by now the petition is only aggrieved to the part of the impugned order with regard to in respect of a direction to issue fresh advertisement for the post of assistant professor as the and not with the cancellation of the selection and appointment of MS Shruti as the said Mrs. Isuti was illegally appointed without having the education qualification, and the petitioner having been selected and placed in the waiting list number 1, the respondent authorities ought to have been appointed the petitioner. Mr. Therefore, she submits that the part of interim order, particularly the direction for issuance of first advertisement, may be set aside, and a direction may be issued to the respondent authorities to appoint the petitioner in the post of assistant professor biochemistry. Mr. Next slide. Mr. T. Tagore, London Standing Council, Health and Family Welfare Department. What is your stand? It's not applicable, are you sure?
My lord, that would not be my official stand, my personal, my lord. Only, my lord, since there's an allegation of personal bias and all, my lord. That's why, my lord, considering this aspect, to maintain all fairness, my lord, the authority has taken decision to cancel an entire process as a void, my lord. And since that has not been reflected also, my lord, so far eligibility part.
Submits that on the allegation of the petitioner placed before the appropriate authorities, competent authorities, the scrutiny board for verification of documents. No, on consideration of the entire matter, it is found that the scrutiny board for verification of the document was headed by one Dr. S. Nageshwar Rao, who is the husband of the E. Shruti, Mrs. E. Shruti, who is the head of the Department of Biochemistry, head of the Department of Biochemistry, and the husband of Mrs. E. Shruti. And thus found of likelihood of personal bias in the case. And having considered that the credibility of the recruitment process in respect of assistant professor biochemistry has been undermined and vitiated, the competent authority, by considering the representation of the petitioner, had cancelled the recommendation and appointment of Mrs. E. Shruti as assistant professor biochemistry. Upon cancellation of the selection process and the appointment of Mrs. E. Shruti in the post of Assistant Professor Biochemistry. It has been directed to issue press advertisement for the same post after obtaining clarification from the NMC. Therefore, he submits that there is no illegality in directing the issuance of press advertisement for filling up the post of Assistant Professor Biochemistry by the competent authority. Mr. Then what about the rules?
Rules, my lord, in my understanding, department understands different, but my understanding, my lord, it is the 2022 is applicable. my lord.
Yes.
But saving clause, madam, I
He-
personally
Mr.
feel that, madam,
Huh.
it is only in the case which would be already serving, my lord. In that case,
Saving clause will apply only
when
in case
appointed under that act
under
and
that act.
continuing.
Yes, if it's continued.
Yes, my lord, that is
Or
my.
advice initiated prior
Yes.
to the
Yes,
coming
yes,
into
ma'am.
force of
Yes, yes,
Regulation
ma'am.
20.
That is,
Yes.
but the department understands something different.
Mr. Tagum, Learned Standing Council. You think that because of this public notice, they think that this 2022 will not apply?
My lord, yes, they are understanding, that's what.
Submits that the
Because of saving
respondent
clause.
authorities, in their own wisdom, is of the view that in view of the public notice dated 25/02/2022,
And my lord,
as well
and
as the
saving clause.
clarification,
My lord.
the clarification from the Director NMC dated 16/12/2024.
My lord, as well as saving clause 14 of the
And the
regulation.
saving clause at clause 14 of the what do you call?
Regulation 2000.
Regulation 2022. That the regulation would not be applied, and the regulation of what is regulation of
2022 would not apply as
would
because
not
my lord,
apply.
as because he was already appointed under 1998
As-
medical institute.
As Mrs. E. Shruti was earlier appointed as assistant professor or lecturer,
Assistant professor my lord,
assistant
in other
professor
medical
in
college,
biochemistry in some other
medical college of the India.
medical institutions in terms of the minimum qualification for teachers in medical institutions regulation 1988.
Yes, madam.
Mr.
And same was duly recognized by the MNC, madam, at that point of time.
Having submitted above, Mr. Next para, Titagum, Learned Standing Council fairly submits that since the advertisement was issued on 15/03/2024 and the regulation, you just give that name. Because when you say that first regulation, you just said in short, regulation 22. But the first, when you say mention that regulation, you just give the name of the regulation. Teachers eligibility qualification in medical institution regulation 22, page 29. Then only you said in short. Which has been published in the official gazette by dated 22/02/2022 is notified on 14 February 02/2022 would regulate the present selection process. He further submits that since the appointment, the selection to the post of assistant professor of biochemistry appears to be vitiated in view of the likelihood of bias and the without there being any clarification from NMC. The authority has rightly directed for issuance of press advertisement by providing equal opportunity to all the deserving candidates. Next one. Due consideration has been extended to the submissions advanced by the learned counsel for the parties, and also there is the materials available on record, including the Regulation 2022. Yes, sir. An advertisement was issued by number so and so, page 18, left side, trim so and so, dated 15/03/2024 by the Director of the Teams Naharlagun for filling up of various posts of professor, assistant professor, and associate professor and assistant professor in various departments, for various departments, including one post of biochemistry. Upon completion of the selection process, which was consist of the interview of the consist of interview held on 3/05/2024 and 4/04/05/2024. A select result was published on 20/06/2024. Whatever. Including the for assistant professor in various departments, including the post of assistant professor of biochemistry, assistant professor biochemistry. In the said result notification, the result select result. The one, she is there as a respondent here. No,
he is not a respondent.
The one MS is routine was selected and accordingly appointed as assistant professor of biochemistry, and the petitioner appeared was selected and placed on the voting list number 1. Mr. It is taken note that the aforesaid advertisement dated 15/0/2024 provides the terms and conditions, one of which is to the effect that the eligibility criteria shall be as per the NMC. Please. The NMC has issued a notification dated 14/02/2022, which was published in the official gazette on 22/02/2024. The teacher's eligibility qualification in medical institution regulation 2022. Mr. Undisputably, the appointment, selection and appointment of the assistant professors, including the teachers, including the assistant professor, biochemistry, would be regulated by the said regulation of 2022. Mr. Close. This the next paragraph. Clause 3 provides for a general norms for appointment of faculty in medical institution, which is reproduced here in under page 29, clause 3, you right? All this 3.1, 3.2, 3.3. Norms for faculty appointment, This clause 6, right?
Your Lordship.
You are referring on clause 6, page 31.
31, yes, Your Lordship.
Norms for
Table,
faculty.
yes, Your Lordship. Table 1A for medical, table 1B for non-medical, Your Lordship.
Table 1.
Table 1A, page number 31. Relevant portion is page number 32. Table 1.
This is faculty and promotion, appointment and promotion, Clause 6.
Clause 6.
Provides for the norms for faculty appointment and promotion. At clause, at table 1, capital A, Interim provides for assistant professor, the education academic qualification shall be MD/MS/DNB in the concerned subject with teaching and research experience of 1 year as senior resident in the concerned subject in a recognized permitted medical college after acquiring MD/MS degree. Stuff. Plus, the table 1B provides the index of broad specialties in which persons with non-medical qualification may be appointed as faculty, assistant professor, and beyond, bracket close, which provides that for assistant, provides that the specialty in biochemistry with academic qualification shall be MSc within bracket, medical biochemistry, bracket close, with PhD in medical biochemistry. Then confused, huh? Be clear. Next paragraph. Perusal of the above rules, above regulations, 2022 clearly indicates, clearly shows that for faculty appointment for the post of assistant professor, a candidate must have the academic qualification with of MD/MS/DNB in the concerned subject with teaching and research experience of 1 year as senior resident in the concerned subject in a recognized medical college after acquiring the academic qualification. List of it also provides that for persons with non-medical qualification, appointment may be made as faculty within bracket, assistant professor, and beyond, bracket close, with the specialty of biochemistry having the academic qualification of MSc within medical chemistry, biochemistry, bracket close, with PhD in medical biochemistry. As per the above provisions of the regulations of 2022, it is admitted position that the petitioner is eligible in all respect, and one Mrs. E. Shruti, who has been selected and appointed within bracket by now they cancel the appointment and selection and appointment of the said Mrs. E. Shruti, bracket close, is not eligible as she appears to have only the MSc within medical biochemistry without PhD in medical biochemistry. Therefore, the cancellation of the appointment of the said Mrs. E. Shruti appears to be in consonance with the regulations 2022. However, since the respondent authorities have not considered considered, has not considered with regard to the scope of appointment to the post of assistant professor biochemistry. Although the petitioner is eligible and qualified in all respect, and he having been selected and placed in waiting list number 1. His case ought to have been considered for appointment. Mr. Does I'm of the considered view that the respondent authorities are deserved to be directed to consider the case of the petitioner for appointment as the selection and appointment of the of Mrs. E. Surti has been cancelled, and the petitioner having been qualified and selected and placed under waiting list number 1. Because I think you better to consider and appoint, because it will save the public fund also to have advertising and all. Because unless she is qualified or some, he or she is qualified, he would not have been placed under in the waiting list.
That is it.
Next one. Having considered the methods in its entirety, and in view of the conclusion made here in I am of the considered opinion that interest of justice would serve if the respondent authorities are directed to consider the case of the petitioner for appointment as assistant professor in biochemistry in TRIMS pursuant to the advertisement and consequential select list dated 20/06/2024. Advertised dated and consequential select list so and so, where the petitioner has already been selected, although placed in the waiting list number 1. In view of the fact that the selection and appointment of the one FS so and so has already been cancelled. Mr. The writ petition stands disposal in terms of above.
Obliged.
Definitely.